You can come a little closer.
Morning, everyone.
Morning.
Morning, Mr. Pratt.
Morning.
Oh, I'm
Morning.
Mr. Clelo, I can confirm that Jerome has to send his apologies. He's in another court.
I'm sorry, Ms. Tucker, you skipped. Can you repeat that?
My apologies. Mr. Lynch has sent his apologies as he is in another court this morning and he's unable to attend these proceedings.
Yes, he communicated, and I understand that you are holding.
Okay.
Okay. So good morning to everyone. I see that we do have our justices now on the call. So this is the Court of Appeal of Bermuda's closing session for November 2020. We have 3 matters listed for decision and 3 matters listed for corrections. The first matter that I am going to call for the decision is criminal appeal number 3 of 2020. That's the Queen against Chaz Rogers. Ms. Cindy Clark of the DPP's office appearing on behalf of the appellant, and Mr. Charles Richardson of the Legal Aid Office appearing on behalf of the respondent.
Yes, in this case, the appeal is dismissed for reasons in the judgment that we now hand down.
Thank you, my lord.
Judgment has been emailed to counsel, so please verify that you have received it. The next criminal appeal will be number 7 of 2020, Kenneth Williams against the Queen. Ms. Sarah Tucker holding for Mr. Jerome Lynch QC for the appellant, and for the respondent, Ms. Maria Sofianos.
Good morning.
Good morning. I just noticed that Mr. Williams isn't in the voting. I'm not sure.
Yes.
Yes, good morning. Yes.
Unfortunately, I can't.
I'm just waiting.
I'm sorry, Chief Balboa, you're speaking, but your mic is muted.
Yes, I'm sorry. You're waiting to see Williams first?
Yes, please.
Okay, no problem.
hello.
Ready? Pursuant to section
I'm sorry, is he there
21.
because my camera is frozen?
Is that okay?
Can someone confirm that Mr. Williams is in the area?
Yes, he is.
Okay, then the decision will be given by my Lord K.
Pursuant to section 21(2) of the Court of Appeal Act 1964, this appeal is allowed. We quash the convictions and direct verdicts of acquittal. This means that there will be no retrial. Our reasons will be provided in writing in due course. Thank you.
I'm obliged.
Thank you. CO Balboa, if I may now have Roberts, Bryman, and Smith Williams.
Okay, thank you.
Thank you.
You pass me a pencil, please. Pass my pencil, please. Second.
Are they in position?
Does not.
No, not yet.
Good morning. I have Kyrie Smith-Williams, Quincy Brangman, and Levesque Roberts.
Thank you.
Thank you.
We have 3 applications to reopen previously determined appeals against conviction. Their common features are that the applicants were convicted of very serious offences a considerable time ago. They each pursued conventional appeals to this court, but their convictions were upheld, and they are now effectively seeking to reopen their appeals as a result of recent legal developments. The circumstances are therefore highly unusual. This is part of the fallout from the recent case of Jamaica Trott in the Supreme Court, a judicial review case in which the Chief Justice decided that the provisions in Section 519 of the Criminal Code, which effectively accorded to the prosecution more extensive rights of challenge without cause to potential jurors than were accorded to the defence, were unconstitutional by reason of Section 6(1) of the Constitution. It is an equality of arms point. There was no appeal against the Chief Justice's decision. The response was legislative. The Criminal Code Amendment Act No. 2, 2020, almost immediately amended Section 519 so as to put prosecution and defence on an equal footing in respect of peremptory challenges. However, it also sought to prevent appeals in past cases based in reliance on Trott. Section 5 provides, and at that point in the judgment, Section 5 is set out. The judgment of the Chief Justice sets out the unamended provisions of Section 519, including the right of the defence to challenge up to 3 jurors without cause, the right of the prosecution to stand by up to 36 jurors, and the right of either party to challenge any number of jurors for cause. In the trial transcripts we have considered, the language used by counsel and the trial judges does not always use the correct terms for these different concepts. Strictly, the defence right is one of peremptory challenge. Standby should be used only in relation to the prosecution's right, which, when exercised, does not remove the juror from the pool. He or she may be reached again when a potential juror is removed for cause. When a potential juror is removed for cause, the correct term is excused or stood down, but not stood by. The applications before us seek to challenge the constitutionality of the 2020 amendment. They seek to argue that it is just as much an infraction of the applicant's constitutional rights as the unamended Section 519 was. The written submissions make clear that a number of important legal issues are involved. We don't use at this stage. When the parties first came before us last week, we identified a potential threshold issue in relation to which we had insufficient information. It seemed to us that it could be said that if in a particular case the Crown had not exercised its right to stand by more than 3 jurors, a defendant could not complain about an inequality of arms. At the adjourned hearing, we were able to receive submissions based on transcripts of the jury selection processes. We are now better informed. The position seems to be as follows. In the case of Smith-Williams, at least 5 potential jurors were stood by at the behest of the prosecution. Although they remained in the pool, they were not called a second time. In the case of Brangman, there were certainly 3 who fell into that category, but there were several others who, having been stood by at the first stage, were later recalled. When they proffered reasons why they should not serve, rather than those reasons being investigated and evaluated by the judge, they were again stood by, either by the judge or the prosecution, or effectively excused. Sometimes the words "stand down" were used, either by the judge or the prosecution. On some but not all of these occasions, it was clear that the prospective jurors were not being asked to stand by, but were being excused. On other occasions, the words "stand down" were used when it was clear that "stand by" was intended. Mr. Mahoney says that this is just a convenient way of saving time, but it does give the appearance of the prosecution playing a privileged part in the selection of the jury. In our view, they should be taken into account when considering the numbers threshold. The case of Roberts is less clear. Initially, the prosecution stood by 33 potential jurors who went back into the pool. Of those, 3 were empaneled on the second time round, and as many as 28 were excused by the judge when they proffered reasons why they should not serve. This leads Mr. Mahoney to submit that only 2 of the original 33 standbys are relevant, the remainder having been later empaneled or properly excused for cause. Miss Greening submits that nevertheless, the picture is one of the prosecution gaming or manipulating the composition of the jury, and that it is redolent with real or at least apparent fairness. We have come to the conclusion that notwithstanding the difficulties, Roberts should not now be treated differently simply on the basis of the numbers threshold. Although that gets the applicants over the numbers threshold, there remain the difficult legal arguments set out in the written submissions from both sides. They are not fanciful on either side. They seem to us to be worthy of consideration by this court at a substantive hearing. It is inevitable that one or more of us will be part of that court. In the circumstances, we do not propose to say anything about the respective arguments at this stage. We add that quite apart from whatever potential force the respective arguments may or may not have, we consider that there is a public interest in their being considered by the court at a full hearing. At that hearing, everything will be at large, all legal arguments and factual issues. Accordingly, we grant leave for the 3 appeals to be reopened. That leaves the question of any directions for the further pursuit of the reopened appeal. We can say that it is the intention of the court that the reopened appeal will be heard in no later than the Easter 2021 session. And so we would like to give directions which enable us to be sure that everybody will be ready when the time comes. Subject to any representations, what we have in mind is that the applicants should each produce fresh written submissions to replace the current ones by the 11th of December, that the respondents' written submissions should be in by the 21st of December. There will then need to be a new composite record of appeal. So far as that is concerned, we propose that the parties attend before the registrar in the week commencing the 4th of January for that to be finalised. There will need to be a full bundle of authorities that should be produced by the end of January, and we direct that it is in double-sided form, not one printed page followed by a blank page. And when the case is listed, it will have a time estimate that we will now seek to finalise. The initial feeling of the court is that the full hearing might be completed within one day, but do council have any submissions to the contrary?
Good morning, my lords and my
Mr.
ladies. I have no further submissions. I believe that it may be able to be accomplished in a day's listing, for a day's listing.
Yes.
My lord, if I may, my lord.
Any council present? Mr. Pettingill.
Thank you, my lord. And thank you for the ruling. My lord, there are the three of us, obviously, and I think we have certainly Mr. Lynch and I have been working on this together, and Ms. Greening and I have certainly worked on Trot together. And the issues, in my view, are the same, and I don't know that anything will be, as a legal issue, particular to one or more of the applicants. And having said that, my lord, and being quite familiar with the areas that are informed, I think that to your lordship's point, it is quite significant, and there's a fair amount to get through. And I anticipate that there will be somewhat cogent and, if not voluminous, submissions with authorities. So I say all of that to say I have a concern that a single day in the circumstances with three council, albeit consolidating their position, and a response from the Crown, and knowing how these things go, may be a bit limiting, my lord. I would respectfully think that it may require 2 days.
Let's just see what Ms. Greening says. Ms. Greening?
Yes, good morning. Can you hear me?
Yes.
Yes, good morning, President, my lords and my lady. I tend to agree with Mr. Pettingill that I don't think that given the various steps that we need to surmount, one day might not be enough, given that there are 3 appeals, various steps, and of course the respondent's opportunity to reply to that after he's made his submissions.
We say 1.5 to 2 days. Will that?
I think 1.5 days. My feeling is that 1.5 days should suffice, but not 1 full day.
Okay, everybody content with 1.5 days?
Well, Lord, I'll be content, but I'll go on the record as hedging on 2 with respect. But I think that, we can see where we get to with 1.5.
Yes. Okay, thank you very much. That disposes of this case for the time being then. But,
thank you, my lords.
Thank you all very much.
Thank you. May I be excused?
Sorry, Mr. Mahoney.
Alberta, may I?
Yes, I'm here, sir.
Mr. Mahoney, I didn't come to you on time estimate. You agree a day and a half?
I think a day and a half to 2 days, sir.
Yes.
Free counsel, and I think from Miss Greening's email to the court on Sunday night, she may be seeking to advance other involved grounds.
Well, we'll have to wait and see.
Probably 2 days might be wise.
Yes. Okay, well, we'll try and ensure that nothing else is listed on the second day.
Perfect.
Thank you all.
Maybe be excused, my lord.
Certainly.
President, my lord, my lady, may I be excused also?
Yes.
Thank you.
May I be excused as well, please?
Yes, Ms. Afianos, thank you.
Thank you.
And thank you to my lords and my ladyship, if I may be excused.
Of course, Ms. Tucker.
Actually, if I may, everyone who's on this call, if you have no further business before the court, but you wish to continue observing the proceedings, you can do so on the court's live stream. It'll help the internet connection so that there's no skipping. So if you have no further business before the court, I'd ask that you remove yourself. Chief Officer Bermuda, may I please have Katrina Burgess and Cleveland Rogers?
I do not have Katrina.
Oh.
I have Chaz Rogers right now. Katrina's at the Courier. I have Chaz Rogers, and I can also get Cleveland Rogers.
Right. That's right. Mr. Chaz wasn't before the court, but the decision was handed down. I defer to my Lord K if he wishes to have Mr. Rogers appear quickly just to advise him what the decision
Just to tell
of the
him
court
that the
was.
prosecution's appeal has been dismissed.
Okay, I can get Chaz Rogers in, yeah. Yeah, I'm through.
I think we're not following.
Come.
He wasn't there when I handed down.
Right.
So I'll just tell him what we did. This is Mr. Rogers. Good morning, Mr. Rogers.
Chaz Rogers, yes.
I'm here to tell you that the prosecution's appeal in your case has been dismissed. We're not giving our reasons for that today. They will be produced in a written judgment, and you'll be able to see that in the next 2 or 3 weeks. Thank you very much. So far as you're concerned, it's good news.
I'll explain it to you later, Chaz.
All right, thank you.
But basically, we won. You're all right.
All right. Okay.
Yeah, you were in there.
Okay.
I'll send you a copy.
I will go ahead and get Cleveland Rogers.
Well, actually, Chief Alberta, unless subject to any other views of the court, I would prefer to put Omar Davy ahead of them for direction, which gives me the opportunity to try to make contact with co-ed to see if Ms. Burgess can join us.
Okay, give me a few minutes.
Okay, thank you.
All right.
Okay, just to update everyone, I have made contact with Principal Officer Tucker at the co-ed facility. He's going to arrange for Ms. Burgess to appear by video link. So I'm just waiting for that to occur and for Mr. Balboa to also produce Mr. Rogers for his directions.
Right.
Mr. Coelho, am I concerned in these next two cases?
I don't think so, my lord.
No. Shall I stop the video and mute?
If you wish to do so, yes.
And there's then going to be a short break, I think, before the civil appeal of Crisson.
There is. Are we going to give directions in Davy?
That is correct.
Coelho, are we going to give directions in Davy?
Well, I had expected for Chief Officer Balboa to produce him whilst we're waiting for the other two co-pilots.
Yes, that's what I'd understood too.
But, I'm not sure.
Let's see what happens.
Well, I think I shall stop video and mute now until we're ready for Crisson.
Okay.
I think that goes for me too, Mr. Coelho, doesn't it?
I want to err on the side of caution and say no, because I still need the composition of the full court.
Fine. Okay,
which
I'll
is
stay
the
on the
president and two other justices.
No, I'll stay on the line.
Okay.
Good morning, this is Omar Davy.
All right, thank you, Chief Officer Balboa. Calling criminal appeal number 5 of 2020, Omar Davy against the Queen. Ms. Elizabeth Christopher from the Legal Aid Office appearing on behalf of the appellant, and Mr. Alan Richards of the DPP's office appearing on behalf of the Crown.
I think all that we need to do is to make some directions. I'm told that it may be necessary for counsel to liaise with Mr. Coelho as to what documents are needed to complete the record. So if that can be done,
well,
please.
Speaking for myself, my lord, there have been some discussions via email with Mr. Coelho about that. I thought that we had come to an agreed position, but if we need to reiterate that, we certainly can.
Okay, thank you very much. Has the affidavit about counsel's alleged incompetence been served on counsel?
Yes, it is, and I filed with the court this morning an affidavit of service that indicates that he was personally served on the 30th of October with the affidavit and certain other documents, the notice of appeal and the like. But we had also sent it to Ms. Greening on the 14th of October via email. So
Right.
you should be well aware of what is being said.
And that included a waiver of privilege. Did it?
It did.
Thank
The
you.
waiver of privilege was sent on the 15th via email of October and then was served.
Right. Thank you. Right. Well, I think in those circumstances, unless I'm corrected, all we need to do is to work out a date for submissions and a date for any authorities. I assume this case is only going to take half a day. Would that be right?
I would
I
think.
agree, my lord.
Yeah. Okay. Well, should the submissions be sequential or come in at the same time?
I would prefer sequential, please, my lord. And I would ask the court to give Mr. Warner a further opportunity to respond to the documents that have been served upon him. It may well be that he does not, but as the court will recall from its order of the 7th of October, he was to be permitted quite a short window in which to respond. It was a very tight timetable because we were trying to get the matter into this session.
Right.
And it wasn't possible. But I know that he's currently in a Supreme Court trial. I'm assuming that this matter is going to be heard in the March session.
It is.
I would respectfully suggest that Mr. Warner could be given until sometime in December to reply if he wishes to do so.
Yes.
My learned friend can have however long she needs after that to do her submissions, and I'll take 2 weeks, if I may, after that to respond.
Right.
Richards and Sir Christopher, would it not be appropriate to order that Mr. Warner respond? If we reached a situation where we simply had no response from him, it would make it rather difficult to conduct the appeal appropriately.
Well, what I think we need is either a response or an indication that he does not intend to respond. He's not obliged to respond. An allegation is made against him. If he's got nothing to say, he's got nothing to say. He can't, I think, be compelled to comment. But if he fails to do so, either certain inferences may be drawn, or the court may simply accept the contentions made which are not disputed. We have to see what they are and what it amounts to. So, why do we not say that, sorry, I'm looking for my diary, counsel should either respond or indicate that he does not propose to respond by December the 11th, that's about a fortnight. If we order that, can the appellant's submissions be made a week later?
On the 18th of
18th.
December?
Yeah.
Yes.
Okay, appellant submissions by the 18th of December. I don't think the respondents should have to respond on Christmas Day.
Might I have until the 8th of January, my lord?
Yes, you may.
Thank you.
And then, are there going to be any or many authorities?
I don't believe so. I don't.
No, I wouldn't expect so, but well, can we have a bundle of authorities by Friday the 15th of January?
Yes, my lord.
No reason why not, my lord, as long as all the other deadlines.
Yeah, okay. Well, that gives some leeway, but that sounds fine. Double-sided and in some order, either alphabetical or chronological. Anything else that arises?
I don't think so, my lord.
No. Thank you very much.
Thank you.
Thank you.
May be excused.
Yes, you may.
Thank you.
May I also be excused, my lord?
You may.
Thank you very much.
You finished
Chief Officer
it?
Bermuda, I understand that we have Principal Officer
Okay.
Tucker on the call with Ms. Burgess. So could we now have Mr. Rogers?
Okay, great. Okay, thank you.
Thank you very much.
I noticed that there's no counsel for Rogers on the call.
Right.
Right. There's someone on the call by the name of Sharon Wilson. Is she a lawyer?
I don't recognize that name as having been involved in this case.
Right. Mr. Richardson, if you have a telephone number for Ms. Mulligan, would it be possible for you to type it in the chat so that I could raise her by phone?
Ms. Christopher's trying to contact her as we speak.
Okay.
You sent Susan a message?
Was she notified of the hearing?
Yes.
Okay.
I think it's supposed to be in the Court of Appeal by Zoom right now.
Rogers.
And we're right on you. It should have been sent, it indicates that we're sent an email. Okay, I'll hold, I guess.
Just for directions. I think Ms. Christopher's going to hold very briefly for Ms. Mulligan since it's just for directions.
All right.
Okay. Calling Criminal Appeals 2 and 5 of 2020, Katrina Burgess and Cleveland Rogers against the Queen. Mr. Charles Richardson appearing on behalf of Appellant Burgess, and Ms. Elizabeth Christopher appearing instead of Ms. Mulligan on behalf of Appellant Rogers. Mr. Mahoney appearing on behalf of the Crown for directions.
Right. Is Ms. Christopher with us?
Ms. Christopher's just gone into her office to sign in, sir.
Okay. Okay. She will be with us. Right.
Yes, sir. Change of plans. Ms. Christopher's going to actually come sit next to me.
Well, that's good.
As frightening as that is.
I couldn't possibly comment on
Sure,
that.
Evan.
Is she with you now? Or?
Yes, sir, she is.
Right. Yes. Good. Thank you very much. Right. Well, all we've got to do is dates for submissions and authorities. But just before we do that, what time estimate have we got for this case, if any?
Well, there are two appellants, and I suspect that these submissions are going to be somewhat involved. I would say at least 2 days, sir.
That sounds ominous. At least 2.
Oh, I'm familiar with counsel who's on the other side, and she's known for being extremely thorough.
Who is counsel on the other side?
Miss Mulligan.
Oh, yes. Yes, she is. Yes. Right. Well, should we set it down for 2.5?
If we set it for 2.5 at this stage, I'm sure as we develop the submissions, if we see that we require less, we can notify the court.
Yes. I would urge a degree of conciseness in relation to the provision of submissions. We have had some recent cases in which there were a myriad of submissions, of which 3 out of 12 were well-founded, but the others were not.
Well, I can indicate, sorry, sir. I can indicate to the court that the submissions in this case for Ms. Burgess are going to be drafted and settled by Mr. Courtney Griffiths.
Oh, yes, right, okay. Okay, well, let's say 2.5 days. Now when can submissions, should they be sequential?
That's the format that I'm used to, unless the court has a
Yes.
different suggestion.
Well, I would have thought so, but okay, well, can the appellant submissions be ready by the 11th of December?
I believe that might be a bit short for Ms. Mulligan, because she's also indicated to me that she is looking for the court smart of the tabs.
Right, okay, well, we have some time. What about the 18th of December?
We can try. She can try for that.
Wait a moment.
It's only
it's a week later, but it's a week later. If we prescribe a date, it's a date that's to be complied with, not just an attempt.
That's why I'm a bit. That's why that's why I caveated what I said. I mean, we do have time on the other side of the year. Maybe
we do.
May consider. So I would propose that it be maybe perhaps the first week in January.
Well, speaking for myself, subject to any views of others, I would be disposed to order by the 1st of January, but upon the footing that that is a final date. What we cannot have is an application made on Wednesday, the 30th of December, saying I'd like another fortnight.
Yes, sir.
So Christopher, if I could just interject.
Yeah.
What I would like to know from counsel is the position of the transcripts, because if submissions are going to be based on further transcripts of evidence, we need to know ahead of time so that that evidence could be produced. Because the standard 310 transcripts have already been produced and provided.
Would the court like to set a date by which we would notify the court if any additional transcripts are required?
Yes, I don't see why that can't be done next week. You must know what transcripts you've got at the moment and whether you need any more. So it seems to me that you should notify the court by no later than the 4th of December, whether you need any or seek any, and if so, which transcripts.
Yes, sir.
And the appellants.
Mr. Mahoney.
Pardon?
The voice.
May I just interject?
Yes.
Based on the grounds of the appeal that has been filed, I believe that some indication could be given in respect of the additional transcript. For example, in regards to Mr. Rogers, there are certain contentions about the evidence of the expert witnesses. Those could be ordered now because we are going to need their evidence in respect of that particular ground. In respect of Burgess, a ground of appeal or a complaint is that hearsay evidence was admitted into evidence. The witnesses in respect of which that complaint is being made, I'm sure counsel could at least give some names now so that we could start getting those transcripts produced from now.
Mm-hmm.
And if it seems to be added, that could be done next week.
Right. Well, it seems to me that both sides, all parties, should provide by no later than Friday the 4th details of such transcripts as they seek, but that they should start doing so now. That is to say, the final list of transcripts must be available by next Friday. But if you know now that you want some, please inform the court. And if you decide on Monday a few more, do that likewise.
Which takes us to the second matter of things. Does that then move the submissions date for the appellant if they're submitting a schedule of lists of names to be transcribed on the 4th? per the transcripts, they're to notify the court by the 4th. And
Yes.
those submissions won't be ready for the 18th.
No. How soon can we get transcripts?
That's something I can't answer to right now
No.
until I've produced the list to Ms. Gazard and she's heard the evidence to give me an estimated length of time to produce them.
Well, we have got some time available. Let us say that the appellant submissions should be in on Friday the 8th, which is intended to be final, unless good reason is shown. And the only good reason I can think of at the moment is that a vital transcript hasn't yet been obtained. And can the Crown, how long do the Crown need for their submissions and response?
The normal time is normally 2 weeks.
Yep. So Friday the 22nd.
Yes, sir.
And authorities by bundle by Friday the 12th. Single-sided and in order.
Single-sided or double-sided?
I'm sorry, double-sided and in order. Not single-sided.
The 12th of which month, my lord?
When are the grounds?
February.
February.
Set down for 2.5 days.
When the grounds get over?
Is there anything else that arises?
Not at the moment, as far as I am aware, my lord.
Thank you very much.
Thank you.
May be excused, my lord.
You may.
Excuse us, well, sir.
Of course. Thank you for your help.
Thank you, Principal Officer Tucker, for the short notice.
Very good. Can we go into our breakout room?
Yep. Judge, do you see the leave to breakout room button?
I don't have one yet, Coelho, though it seems to me I can properly leave the call completely since I'm not involved in Christen.
Oh, okay.
But I would prefer to do that having
Spoken with the others.
Yes. But I don't have a exit to the breakout room option at this present time.
I'll come to you.
Right. I've only got the red leave option, which takes me out altogether. Oh, here we are, join breakout room. Yes.
Coelho, how nice to see you again.
Pleasure to see you also.
Ah, Mr. Hill.
I believe we have Mr. Chai here.
Can't see him. Oh yeah, have we got him? Yes, we have.
All right. So
Right.
I'm now calling Civil Appeal number 9 of 2020. Andrew Christen against Marshall Dillon Myers Limited. Mr. Cameron Hill on behalf of West Hill and Co. is appearing on behalf of Mr. Christen, and Mr. Pichai of Wakefield Quinn is appearing on behalf of Marshall Dillon Myers Limited.
Right. Before we start, can I first say thank you to everybody for producing with some considerable speed the record of appeal and the authorities. I don't mean to detract from those thanks by observing that the documents are not in entirely perfect condition. Firstly, the exhibits to the first affidavit of Mrs. Marshall, which is at tab 3 of the record, do not tally with the affidavit. That is because pages 5 and following of the exhibit have not been included, and what has been included in the exhibits to the first affidavit is in fact the exhibit to the second affidavit of Mrs. Marshall. Tab 7 says second affidavit of Marshall, Georgia Marshall with exhibits. That's only partially true. It contains the affidavit, but not the exhibits to the affidavit. I think we may need in due course, it's not urgent now, the remainder of the actual exhibits to the first affidavit of Mrs. Marshall. In addition, I can't find the order made by Justice Stoneham on the 7th of November of 2019. It may be that it's somewhere in this morass of documents. What is capable of being found is the judgment of Justice Stoneham, the long judgment in November 2019, which is at tab 6. But I give notice that I haven't yet been able to find the actual order made, although it is referred to at paragraph 32 of the respondent's argument. I won't delay matters anymore. I just give notice that, speaking for myself, I should like to receive in due course the remainder of the exhibits to the first affidavit of Mrs. Marshall, and either the judgment of Justice Stoneham of the 7th of November, or to be told where I can find it in the bundles. Yes, Mr. Hill.
It's in the exhibit to First Christen.
Is it?
Yes. The judgment of Stoneham is in the exhibit to First Christen. It's the last document.
I thought I had it in the respondent's submissions as well.
Well,
but that may be a false memory.
The last document is the 168 paragraph. I had thought that there was a separate order. I see. Okay, if there's no separate order, that's fine.
I wasn't involved. I wasn't involved in the matrimonial proceedings, my lord. So,
okay.
The reason that the ruling is in there is because it characterizes the legal fees as debts, which was ranked pari passu with the other creditors. And now a different story is being put before us. That was the only reason it was included in First Christen.
May I just say also that I will try to locate, my lord, the actual order that arose from that judgment.
Yes.
Send it to you separately if it's not already there.
I'm finding it very difficult to hear you, Mr. Patrick. I think you're some way away from your microphone.
Let me see if I can do something about that. How about that?
That's much better. Your Your skeleton at paragraph 32 says, taking the relevant matters in turn, the Supreme Court order dated the 7th of November 2019 by Justice Stoneham, pages 13 to 17 of the exhibits to Mrs. Marshall's first affidavit.
Right.
You've just told me it's the second affidavit.
No, I didn't say that. I said if it wasn't already here, but let's see if we can find it in her first affidavit.
Well, we can't find it in the reference that you gave.
No, my lord, the reason for that is the reason you've just mentioned, which is that part of the exhibits to her first affidavit do not appear.
Quite.
Yes. So I will obviously have to obtain those and provide them to Mr. Quayle.
Thank you.
My apologies for that.
No, it's okay. Right. Having got that out of the way, Mr. Hill.
There are a couple, if I might begin by this. There are two authorities which were intended to be in the bundle, which have not made it there. I think that's broadly my fault. One of them, Mr. Quayle and I were discussing, but I don't think we came to a final point of which one I actually wanted. And the second was simply omitted by me by chance. They're relevant to the point of whether or not the compromise agreement, the acknowledgement of debt, discharges the obligations under the retainer. I've sent them to Mr. Quayle, and if your lordships and your ladyship wish to see them, I'm sure we can make some arrangements. They are.
Well, if you want us to rely on them, we'll need to see them.
Quite. If Mr. Quayle can give me a hand with getting them to you, then I'd be very, very excited. They are the BCCI case against Ali and the Russian Gazette case, which is in the King's Bench reports of 1933. That's the two that have caused me a bit of trouble. I also noticed in my bundle that there was no exhibit to Second Marshal. I don't know how many of us need it. I certainly did, and it's in my bundle, but it's not in the bundle before the court.
Well, as I've just said, the exhibit to the second affidavit of Mrs. Marshall appear to be contained in the tab which has the first affidavit of Mrs. Marshall.
Very well. I didn't hear that. I'm sorry, my lord.
My lord, they were sent to you separately because I noticed that the exhibits to the second affidavit were not included in the bundle. They were sent to you separately with my submissions.
They were as well, yes.
Okay, well, that's okay. So long as we're all okay with that, I would ask Mr. Quayle, can you help me with those two authorities that I sent this morning?
Yes, I've just forwarded them on to the judges now.
I'm grateful. Thank you very much. In which case, I have an hour. We'll hit the stopwatch at 10:22, and I shall begin. This application before your lordships and your ladyship is born of an application to vary a Morava injunction, what I characterize as Morava injunction, to include what are known as the Angel Bell exceptions, which are the living expenses of the individual against whom the injunction is aimed, the course of business expenses, and so on. That application came on before the Chief Justice, following a range of complaints from myself about how this case was dragging along and not really making any progress. His lordship was kind enough to list the variation application so that Mr. Christen might be able to have his expenses. But sadly for Mr. Christen and myself, he found that the injunction was not a Morava injunction, but in fact a proprietary injunction. And the first thing I challenge is that very finding. And I say that there was no grounds upon which the learned Chief Justice could reach that conclusion, or did he reach that conclusion contrary to all of the evidence. And the starting point for an examination of the nature of the release sought that morning would be the writ, which your lordships will find at tab 1 of the mini record, which sets out the claim advanced by the plaintiff at the outset. And it's the statement of claim, which I think is quite telling, or I submit actually is quite telling. And the claim is set out as follows. The plaintiff was at all material times a law firm. The defendant had been a client, although I would take issue slightly with that all material times. And on or about July 2012, the defendant retained the plaintiff to provide legal services in relation to his matrimonial proceedings. On the 11th of January 2018, the plaintiff...
You don't need to read the whole thing to us, Mr. Hill.
The point that I wish to take from that is, one, the relief sought is damages and not, there's no mention of there having been a repudiatory breach, which repudiatory breach was accepted. There's no mention of a lien. The word proprietary doesn't appear. This is a simple claim on a contract in debt, although I submit that they have inserted the wrong number. And I'll go to how they came by that number.
It's not a claim in damages.
Well, exactly. I think that's what the whole.
You said the judgment relief sought is damages. It is.
Pardon me. I apologize. The claim is for a monetary sum.
Yes.
And not for and not any proprietary interest, a declaration of that interest, or how that interest could be protected, and where the fund. And I want us to keep in mind that there is a difference between a fund with a capital F and no S, and funds, which are described fungible money or money's worth. That application is supported at tab 3 by First Marshal, which sets out the basis of the claim. And again, without reading it, the basis of the claim is the acknowledgement of debt. And not the retainer. And again, the document does not contain the word proprietary, it does not contain the word lien, and it does not contain the word solicitor. And it supports a claim in debt.
Does it refer to a lien?
The first affidavit of Georgia Marshall.
Yeah.
I couldn't find it.
I mean, I haven't
No,
seen
it doesn't. It doesn't refer to a
if you-
lien. I don't believe so. My reading hasn't seen the word lien, and all of the entire document is dedicated to the existence of a retainer between the parties, the order of the judge to terminate that retainer and to allow the plaintiff, the respondent to this appeal, to withdraw from acting, and the replacement of that retainer by the acknowledgement of debt, which provided this cascade of payment.
Well, just a moment. You say it doesn't use the word lien, but if you look at paragraph 28 under the conclusions, and at one stage she refers to the application being made under Order 29.
That's
and at
right.
28, she says, accordingly, I'm bringing this application to preserve the funds transferred into the defendant's sole bank account in order to ensure the payment of the outstanding legal fees.
Yes, and when I take that, that's where I draw the important grammatical or syntax distinction between funds with an S and a small f, which is synonymous with money.
Well, that's a bit artificial, isn't it? We all know that $400,000 was transferred into his account. Those could be regarded as either a fund or the funds. I mean, since there was more than $1, it could be used in the plural. But everybody knows what's being talked about. It's the 400,000 transferred into the account.
Which is the only way she can get her fees paid, which is why she doesn't freeze a fund. She freezes every account. We'll go to the terms of the in a moment.
That was a mistake, because what was sought at paragraph 4 of the affidavit was that the defendant must not dispose or diminish funds in the sum of 400,000 held in his personal HSB savings account. In fact, the order made was related to any account, but actually what was sought in the affidavit related to a particular fund.
In the context of the whole affidavit, what is sought is the arrest to prevent him spending his money other than on her fees. And it is not an application for a fund, and it doesn't identify one and how the interest arises. You can't, I would submit, talk about a fund that is yours in which you have a proprietary interest without identifying how that proprietary interest arises. It's not good enough to say we're looking to establish our interest in this sum of money. What has to occur is that you identify the mechanism by which the proprietary interest arises, and the basis of this claim, the entirety of this claim, is the acknowledgement of debt. Had she been claiming, or the firm been claiming in relation to an acknowledgement under the retainer, then we wouldn't have had such a long story about how the retainer was brought to an end by the judge's order, how they did another deal, set up a new retainer.
I mustn't interrupt, but the acknowledgement of debt is an acknowledgement of debt under the retainer.
Well, it's not, it has a different number. There's a settlement. So they reduce.
I know, but if I instruct my solicitors and he says, you owe me $100,000, and I say, can't we settle on 95? And he says, oh, all right then. And we sign a document in which we agree that the cost will be 95. That simply means that the amount now due under the retainer is 95, not that there was never any retainer at all.
No, that's not what I say. What the termination of the retainer would have kept alive all of the rights that existed prior to its termination. That is the lien, the right of Mr. Crisson to review the bills, the right to challenge the professional standards that he was received, and the acknowledgement of debt terminated the future of the retainer and converted everything into a liquidated debt in an amount less than the sum paid, an agreement to pay.
If my solicitor acts for me until the conclusion of proceedings, after the proceedings, he says, you owe me 100,000, and I say, couldn't we settle on 95? Are you saying that the mere fact of doing that means that I lose the lien that I have in relation to any of my fees?
I say there are circumstances in which that can happen, and these are them.
Why?
Because what the agreement sets up an entire payment mechanism, including the payment in advance of the continuation of a new retainer, in which they'll complete the divorce proceedings for Mr. Crisson if he pays them $50,000 in advance as a fixed fee. And what this agreement does is provide to each of the parties. To Mrs. Marshall, it provides a right to be paid by third parties in the event that Mr. Crisson is insolvent. It creates an immediate right to payment for future fees on the continuation of the retainer or a new retainer. And it sets up a payment mechanism in which all of the fees, apart from the installments, are paid by third parties or attempted to be paid by third parties. And so I say that it creates an agreement, not just because it settles the case, but because it provides under its terms for the payment of future monies, the resolution of the outstanding debt, which once recognized cannot be complained about. Until that moment, Mr. Crisson would have had a right to make counterclaims in respect of professional negligence. He would have had a right to have his bills reviewed by the Bar Council and by the registrar as the taxing master in Bermuda. All of his rights disappeared on that day as well. And we know that to be true because if you look at the submissions of Mr. Richards on the variation application, which appeared time
Could you tell me?
Yes.
Mr. Hill, could you tell me the date on which you submit that the lien, the solicitor's lien, was lost and/or the retainer was replaced by a new agreement?
January the 22nd, isn't it, or the 18th? The date of that agreement.
Well, is it the 22nd or the 15th?
I think it's the 22nd.
Well, you think or you submit?
That agreement was signed. It was the subject of some negotiation. I was going to get to that in a moment, of how this agreement came to be born and why its terms are the terms that they are.
So the agreement, which is the acknowledgement of debt and payment, starting off, the following payment agreement is associated with the outstanding debt.
Yeah.
That's the agreement that you say terminates the retainer and any lien.
Yes,
Is that
that's
right?
right.
Does it terminate the retainer contract?
It terminated, the retainer contract was terminated by the order of the judge who allowed Marshall Deland Myers to come off the record.
No, it wasn't.
But that would keep it,
The order
that
of
would
the
keep it.
That's wrong. The order of the judge provided that they could come off the record. The order was in fact never served, and therefore under the rules has no effect.
Well, it was signed.
It was never served.
I take that point, and that it's an interesting distinction, but it's
Well, of course, it's a completely vital distinction because the rules provide, in effect, that the order is not to take effect until it is served on the counterparty.
it was notified to the counterparty.
What?
It was notified to the counterparty. The counterparty was present when the order was made. There's some nice subtleties about how this order, what the effect of this order. If Mr. Christen is in the room when the judge makes the order, then there's no need to have a written order at all. All of the coercive powers of the state come into being.
No, it has to be served on the counterparty to Mr. Christen.
Mr. Christen was there.
The counterparty to Mr. Christen, Mrs. Christen.
Very well, I can see that. But the agreement itself has the effect of terminating the retainer because it sets up an entirely new method of proceeding. What are we going to do in the future? You will pay me $50,000 within the next couple of days, which he duly did.
Where does it say that in the agreement?
It says that in the affidavit of Mrs. Marshall. First affidavit.
Well, you'll have to show me that.
Where she sets up how the whole arrangement was made.
Well, what paragraph? I'm in the first affidavit.
Yes.
Oh, Mrs. Marshall. What paragraph are you looking to?
Paragraph 9 and following.
Well, no, that won't do.
And she says, paragraph 9, I cease to act as attorney of record on behalf of the...
Which paragraph are you reading from?
Paragraph 9. I cease to act, paragraph 10 says, by letter dated 15th of January, the defendant confirmed his arrangement to the following terms for payment of his legal fees. And then the last paragraph 5 deals with the ongoing retainer. So the ongoing retainer will no longer be under the terms of the previous retainer. It will be a $50,000 payment, which will cover all future fees. And that sum was paid. And it's common ground that it was paid.
Although in fact, the agreement of the 15th of January is never entered into.
The $50,000 term was met and paid. It was part of the agreement, my lord.
Yes, but the agreement of the
ground.
15th of, I quite follow that the $50,000 was paid, but the agreement of the 15th of January wasn't actually entered into.
No.
What was entered into was the agreement of the 22nd of January.
Yes, but by that time, I think the $50,000 had been paid.
Yeah, okay.
$50,000 was paid between the letter of the 15th and the agreement of the 22nd, is that it?
I can't say with precision which day it was paid, but it definitely was paid, and it wasn't included in the formal agreement.
So you say that whenever the 22nd of January agreement was signed,
yes,
that terminated after Mrs. Marshall thought she'd been removed from the record. That terminated any previous retainer and entitlement to a lien, and was simply a agreement for payment of an outstanding
And
debt.
it also included the payment of the retainer going forward, which was at 50.
Well, no, that had
Yes,
already
yes,
happened.
but it was part of the, it was part of the general, it was part of the general agreement as to how things were to unfold. That part of the agreement, one of the preconditions of the agreement coming into effect was the payment of the $50,000. And that payment was made in accordance with the agreement that they had reached. How it wasn't included in the formal written agreement, I'm unable to say, but it was a term of the agreement. And that has never been a matter of contention. And it's averted to in the submissions made to Stoneham, I believe, which we're going to go through in a moment. But that is an agreement that produces an accord and satisfaction. The consideration being that Mrs. Marshall gets paid $50,000 immediately for future earnings, that she releases them. The consideration for Mr. Crisson is that he's released from any, he establishes what he owes them in the past, and that's a sum less than the sum that had been billed or to be billed. And we know that it ended Mr. Crisson's rights to complain about the bill, because that is exactly what Mr. Richard says in his submissions on the variation.
Sorry, Mr. Crisson was released from what?
What he had, what Mr. Crisson got out of it was that his future fees were fixed at $50,000.
Yes. Yep.
And that he had a $60,000 let off in his arrears. And what Mrs. Marshall got out of it was $50,000 in advance, and that's always a good thing. And she got a cascade of payments and guarantees from third parties, given Mr. Crisson's precarious financial position.
You said the defendant is released from, and then you didn't complete the sentence.
He was released from paying the $60,000 because the amount that he owed was $60,000 more than the recognition. And
yes.
Sorry, where do we see that in the two agreements?
That's in Mrs. Marshall's affidavit and in their submissions made to the.
No, forget the submissions. Where do we see the release? I'm looking at paragraph 10 of Marshall's affidavit. Where do we see the release in the summary she gives of the letter?
Okay, paragraph 22 of Mrs. Marshall's affidavit. She says the defendant's total debt owed to the plaintiff for outstanding legal fees are $282,000 odd as of the 12th of December 2019. And in paragraph 23, she said, it is noted that as indicated above and agreed between myself and the defendant, the fees incurred in the underlying divorce proceedings were capped at 50. MBM wrote off 60,000 in fees in keeping with the said agreement. So it's agreed that she will release Mr. Crisson of the obligation to pay $60,000 of his fees and fixed it at an amount, at the amount that appears in the agreement, which was not the sum that was then said to be owing. And that each of those represents mutual consideration between the two. And then Mrs. Marshall is the real bonus for Mrs. Marshall is that she now has genuine guarantees from a solvent person, the daughter. The trustee refused to give a guarantee, of course, but she could hope for something from him. And Mr. Crisson made good by giving her $100,000. The $100,000 added to the $150,000 that arise under the guarantee on the Manhattan apartment, in fact, extinguished the debt, or very nearly. And then the fourth clause says that if there's any change, any balance due after that, Mr. Crisson can pay us by $1,500. I reading between the lines of this, the sum that would be owing would be somewhere around $8,000 to $7,000. But I'm not 100% sure what the sum owing after the guarantee is paid. And again, it's common ground that they've attempted to enforce the guarantee against the people that own the flat in New York. So this is a self-contained agreement, which gives advantages to both sides, provides alternative security to the lien, and acts as an accord in satisfaction.
Of what?
Of the then existing debt. The consideration for the extinguishment of those obligations are the mutual promises contained in this agreement. And this agreement is relied upon by Mr. Richards in the variation application itself, as preventing Mr. Christen from challenging the amount of fees owed. That's what it, and for Mrs. Marshall, she got.
Take us to that. You'll have to take us to that.
I'll take that. Well, we might as well go there now. It's, I think tab 18 of the mini bundle.
These are the submissions of Mr. Richardson on which application?
The variation application before the Chief Justice.
It's at tab 18, my lady.
Yes.
Paragraph.
I'm just going to find it right here, pardon me. Can we come back to that a bit later? I have that noted for one of my submissions, but I'll point that out. The point at which he says Mr. Christen is no longer allowed to challenge the amount owed as a result of the acknowledgement of debt.
Well, help me on this. I quite follow that what you say, that an agreement was made that the fees for the future would be $50,000 and the fees for the past were 280 or whatever it was. And that meant that the solicitors couldn't claim any more than 280 for the past and couldn't claim any more than 50,000 for the future, which they'd already been paid. I understand all of that. So the fees are agreed. But the fact that fees are agreed doesn't, absent anything, something specific, mean that there is no lien for the fees.
Well, it does if one follows the logic of the principles involved with compromise and settlement and the discharge of the obligations in the previous agreement. That once you settle an agreement, you don't go backwards to the old agreement to look to the rights and obligations that it creates.
It depends what you mean by settle an agreement. What they were settling was the fees.
And the mechanism of payment.
Yeah, well, if you look at the mechanism of payment, the principal mechanism of payment, because it was thought that you'd never get to the guarantee, was that the trustees would be asked to exercise their discretion to release sufficient funds to clear off the debt.
Yes.
So that indicates that it was intended that the payment would come from the debt. What in fact happened was not that the trustees gave the relevant money to somebody else, but that they gave it to Mr. Christen. In those circumstances, it wasn't necessary to get well, in a sense, it wasn't necessary to get the trustees to pay the firm because Mr. Christen could do so.
And Mr. Crisson paid.
If the position was that the 400,000 had in effect been recovered by the solicitors, why then they would have a lien on the recovery now in Mr. Crisson's hands.
Let's take that bit by bit.
Mm-hmm.
The original intention was to get the trustees to join into this agreement and guarantee that they would pay. They indicated that they would not pay. They would not become a party to the agreement. And when the question was asked of them, both by Mrs. Marshall and by Mr. Crisson, and at that point, Mrs. Marshall was asking for the payment of the full 400,000, not just the outstanding fee amount. The trustees refused to make that payment. And then Mr. Crisson said, very well, just give it to me and I will sort it out. And what he did was he made the payment of 100,000, which would allow the terms of the acknowledgement of debt and the cascade of payments that it contains to extinguish the debt in accordance with its actual terms. Because once he'd given them the $100,000, they get their $150,000 on the guarantee. They are effectively paid. And one has to bear in mind that they've already been paid $350 before this. So it's not like he was.
I'm not sure that works, because if you look at the guarantee, if you look at paragraph 2,
yes,
I guarantee that upon completion of the case, I will ask that the trustee exercise their discretion to release to the firm from the net equity of Mirabeau sufficient funds to clear off my debt.
Yes.
If there are insufficient funds received from the sale of Mirabeau, well, in fact, there were sufficient funds received from the sale of Mirabeau to pay off the debt.
Yes.
Or if the trustees do not exercise
it's the or that I.
What?
So if the trustees refuse to exercise their discretion.
No. What it says is, or if the trustees do not exercise their discretion in my favor. In fact, that's precisely what they did, because they gave him the 400,000 rather than the firm.
In his favor in requesting the monies to be paid to the plaintiff respondent. And then when they were paid to him, he didn't run away with them. He paid a sum of money to the firm that would see them made whole.
Well, no, he didn't actually pay sufficient funds to clear off the debt.
Well, one has to remember that by clause 1, he'd been paying $1,500 a month for 18
but even
months.
with that, he didn't do so.
Pardon?
Even paying $1,500 per month, he didn't pay out enough.
My understanding is he did. Certainly, it's not said that he didn't. I believe the sum outstanding is something like 156 or something like that. It's
right. So he didn't.
Well, the 6,000 is to be paid in accordance with clause 4, which is the 1,500. And to put it this way, this whole set of proceedings, if the plaintiff respondent had simply done nothing and waited for the New York apartment to be sold, collected their 150, and then had Mr. Crisson finish the job off with a couple of payments of $1,500 a month, they would have been made good in accordance with what they agreed. There's nothing extraordinary about what occurred. Now, Mrs. Marshall may have been disappointed, but nothing that happened breached that agreement, because it was entirely envisaged that the trustees would not exercise their discretion in accord with, in other words, to positively respond to Mr. Crisson's request that they pay the trustees. And Mrs. Marshall was astute to write to the trustees and tell them what was coming and how they should react. And they were reluctant to do so. Now, whether or not they were right, but they were entitled to not do so, because it was entirely contemplated that their discretion would see $0 paid to Mrs. Marshall. And upon receipt of the money by Mr. Crisson, and he has other creditors, and upon receipt of the money by Mr. Crisson, he didn't run off and enjoy a long cruise through the Caribbean. He paid Mrs. Marshall, the firm of Marshall, Deal and Myers, $100,000, a quarter of his worldly wealth, and he saw that what would occur was exactly what everyone had agreed.
But that, well,
I mean, if your lordship takes the view that the first clause meant that if Mr. Christen received the money, he had to pay it to Marshall, Deal and Myers. That's not what it says.
Sorry, which?
No, from what I'm hearing from your lordship, there seems to be an implication that if Mr. Christen receives the money from the trustees, them having refused to exercise their discretion to pay it to Marshall, Deal and Myers, that was somehow a breach of the agreement. That does not appear to, that agreement entitles the trustee to pay nothing to Marshall, Deal and Myers. And that Mr. Christen, having received the money, did in fact pay something to Marshall, Deal and Myers.
Yes, but your problem is that Mr. Christen did in fact receive the 400,000. And that 400,000 is said to be the fruits of the activities of the solicitors, because it enabled him to recover 50% of the value of the matrimonial home held under a nuptial settlement in circumstances where the court could have made a completely different order, giving it to the whole of it to the wife. So what he said is that the 400,000 represents the fruits of the solicitor's activity, upon which, under classic principles, in relation to which, under classic principles, they have a lien.
And my response to that is that they entered into an agreement which provided for alternative security, and in accordance with the authority that appears at number 11 of the authorities bundle, when alternative security is taken, it's cited in my submissions, in fact. They abandoned their lien for an alternative security mechanism.
Well, I don't think it does say that. I think the authority of paragraph 11 says not necessarily. Indeed, you quote it.
Yes.
You quote it in your submissions, helpfully, at paragraph 8. Whether a lien is waived or not by taking a security depends upon the intention expressed or to be inferred from the position of the parties and all the circumstances of the case. In each case, the question whether the lien has been waived by taking security must be decided according to the particular circumstances. I do not mean to say that by taking a security necessarily imports an abandonment of their lien, but if there are circumstances in the taking of the security which are inconsistent with the continuance of the old security, it is to be inferred that the solicitor intended to abandon his lien.
That's what I say has occurred here.
Where? Why? How?
Because of the entering into an alternative agreement that saw their future fees paid in advance and their past fees paid by another security mechanism involving third parties. And that is an abandonment of the lien that would have existed at common law, or as described in Edmonds, the solicitors.
Okay.
And the decision and the idea that that agreement terminates the previously existing obligations appears to be accepted by Marshall, Deal and Myers in their submission, which I shall find the reference in a second.
Mr. Hill, the passages you're looking for, I think, in the submissions in front of the Chief Justice at tab 18.
Yes.
First of all, paragraph 8, in the middle of paragraph 8, where the writer of the submissions says, what must not be forgotten is the false outrage of the defendant is that he agreed the amount of legal fees which he owed MDM and the mechanism for payment. Exchange for that agreement, MDM heavily reduced its legal fees, etc. And then further on at paragraph 11,
yes,
where they say expressly that in the light of the agreements, he's now not allowed to complain.
That was precisely my point.
And over the page at B, there's the allegation that even if the defendant had not signed the agreement, MDM asserts the funds are subject to solicitor's lien. I don't quite understand the thrust of the original clause.
And that demonstrates that at least that the respondent believed that the effect of the acknowledgement of debt was to terminate Mr. Christen's rights to have his fees reviewed. And it contained mutual promises and releases, and that must have included their solicitor's lien, which was one of the rights that they had under the, and Mr. Richards was at the time the managing partner of Marshall, Neal and Myers, or at least a partner or director. He might not have been the managing partner. And that rather confirms what I've been saying from day one, is that this is a claim on a note, and that note is set out in the acknowledgement of debt, and the payment mechanism is contained in it. And that agreement acts as an accord and satisfaction, as I believe it's called in the texts, and thereby terminates the obligations and rights under the original agreement and replaces them in extenso with the rights and obligations in this agreement. And there is nothing that prevents this agreement from being fulfilled. And I go further, I say there is no allegation of a breach of this agreement in either the writ, the affidavit, or the transcript of what transpired before the learned puny judge, where the reasons for the injunction being sought were set out clearly, and the basis upon which it was being sought was set out very clearly. And none of them involved the retainer. The retainer was not included in the affidavit. None of the bills were included as part of setting up any of the claim. The entirety of the claim is based upon this note. For that truly is what it is.
But Mr. Hill, I don't understand the relevance to the issue as to whether there was a proprietary claim, as to whether there was subsequently a breach of the agreement or not, whether paying the money, getting the trustees to pay to him and him paying into the account, or him failing to pay it out of the account was a breach. That's a separate point.
It is.
Surely your argument that there was a proprietary claim here, that there was no proprietary claim here because there was no continuing relationship, depends on an analysis of the agreement that's reflected in the correspondence and in the acknowledgement, and whether that does in fact exclude the solicitor's lien under the previous relationship.
Yes, and replace it with alternative security.
You've got to decide, isn't it? And that involves presumably an analysis of the agreement, and perhaps also, I don't know, because I haven't read them all yet, the correspondence.
Yes, and it will involve an analysis of how the claim was actually formulated. Was the claim formulated as a proprietary claim as a result of the lien? Before
the separate point.
It's a separate point, but
if there had been a proprietary claim, the fact that the claimants were slow in pleading it as such is they did in the end claim a proprietary claim.
They
it
do.
May have been unfair to Mr. Crisson that he hadn't had sight of the writ at that hearing, but that's a separate point.
Yes, but when Mr. Crisson came in and saw me on the 17th of December, the only documents I had available to set up my defenses and to support the application to set the injunction aside were the writ, the affidavit, and the tape of it's not a tape, I betray my age there, the disc of what transpired before the learned puny judge. And so this whole case has been based on there not being a proprietary interest, and no proprietary interest had been pleaded at the time of the variation hearing. Not to me anyway, I hadn't seen it. And so that was how
yes, but you knew what the claim was going to be at the time of the variation hearing.
It had been intimated, but the pleadings are important, and we had been proceeding on the basis of what we saw before us. And what we saw before us was a claim based on an acknowledgement of debt and not on a retainer.
Yes, but you knew what was going to be pleaded. There'd been a letter on the 20th of February
Yes.
from MDM, about 5 pages, citing a number of ancient authorities, which made it entirely plain that a claim for a lien was going to be
Asserted, yes.
And you dealt with it in your responses, saying
Yes.
claim was a nonsense.
Yes.
So you weren't unaware of what was in issue.
No, and that's not quite what I said. What I'm saying is when I was first consulted, what I was confronted with did not raise a proprietary claim, and that is how this all
I know
got
you
started.
said that, but what I agree, it was in response to that I said, but by the time of the application to the learned Chief Justice, it was clear what was being sought to be said.
Yes, although it hadn't made its way into the pleadings yet, or pleadings I'd seen, nor had there been an affidavit swearing that it was true.
Well, you don't need an affidavit in relation to pleadings.
To amend them, you do.
Do you?
I've usually done it with an affidavit setting out why these statements are true.
Not sure about that, especially if it's a new legal way of dealing with matters.
Well, be that as it may. But I do say that once they entered into that payment agreement, because it produced a whole lot of advantages for them, because Mr. Christen was arguably insolvent, and if monies were flowing from him to them, then there was arguably, I put it no higher than that, a possibility that they might be returned. The monies owed by Mr. Christen to the respondents are described in the ruling of Stoneham PJ in the divorce as debts, and they are placed in the same column as debts to the bank and to everybody else. And no one suggested at that hearing that there was a claim to them that would mean they wouldn't, that there was a claim that would remove the solicitor's claim and make it proprietary, so that the funds made available to Mr. Christen by the judge would be extinguished by that proprietary claim and would not be available to assist with the payment of his other debts. They are not characterized as being debts. They are not characterized as being debts to which some kind of security is attached. In the ruling, well, in the affidavit of Mr. Christen in the divorce proceedings, in the submissions of Mrs. Marshall in the divorce proceedings, and in the actual ruling, which is attached to First Christen, in which they appear in the list of debts owed, and how much he's paying on them is $1,500 a month. And so there was never, until it appeared like a nice wheeze to prevent Mr. Christen getting his hands on his money, any notion that there might be a proprietary claim against these funds. And that would be because the claim to the proprietary interest was compromised by Mr. Christen giving up all his rights to have the sum owed reviewed, or a professional negligence claim made, because the fees paid exceeded the value of the state. Well, Mr. Christen's fees were somewhere in the region of 600 in total. And that is a very large sum. And he would have been able to have that reviewed by the Bar Council and the registrar had he not acknowledged this debt. And so it's not quite fair, my lord, to say that it's simply a changing the amount. It has significant consequences for both of the parties. And it created a whole new set of arrangements. And in fact, it created a new retainer, because the terms of the new retainer were that you pay me $50,000 in advance, and I'll fix my fees at that amount. And that too is an enormous advantage to a firm of solicitors who are dealing with a client who's beginning to struggle financially. And so there are advantages and disadvantages for both parties to the entering into the acknowledgement of debt. And its effect, according to Mr. Richards, was to extinguish Mr. Christen's rights to have the number, to challenge the number, because he'd agreed it. And if it extinguishes all his rights, why wouldn't it extinguish all of theirs? Now that's a rhetorical question, but it becomes obvious. The effect of this agreement and what people believed were the effect of this agreement is obvious from the conduct of the parties, including the submissions of Mr. Richards in the variation application. And unless you're,
Are there any authorities, Mr. Hill, on how long a solicitor's lien survives? I know you've referred us to some authorities, but I'd just be and I know you've referred us to authorities which deal with the issue when a lien or when it's replaced by a subsequent agreement. But what's your best case on what you say is the situation here, namely a new retainer going forward, and therefore the expunging or removal of any client's right to challenge of fees and any corresponding solicitor's lien? What's your best case on survival or non-survival of the lien?
The case that I've cited, that if you take alternative security in the circumstances, and I say these circumstances of creating the new retainer and dealing with the arrears at the same time and providing security which will now extinguish the debt, but for a little bit of money, which is dealt with the mop-up clause in clause 4, I say that meets the conditions which are set out in the very old case.
It's Taylor-Stillman that you're relying on.
Yes. And I say that we're not quite on all four with Edmonds anyway, because in that case, the solicitor, and in the place of the solicitor, in our case, we have the trustees, the solicitors had agreed to the cost regime contained in the protocol for road traffic accidents. Whereas in this case, the trustee had expressly not agreed to becoming liable in any way for the fees under the circumstances. And that's why the agreement was slightly changed and the amount of the guarantee on the Manhattan apartment was increased from 100 to 150. Or that's what counted. I don't know why they did it, but that's certainly what happened when the trustees were absolved from paying any money. Because the trustees had no obligation to pay any money to Marshall, Deal and Myers. And one can imagine dealing with a client that's in debt, that this amounts to his entirety of his worldly wealth, why a trustee would be reluctant to give all of it to what appeared to be a single creditor, and would leave it to the beneficiary to work out what to do in fairness. And in fairness, he gave a quarter of it to Mrs. Marshall, which permitted, as I say, the quasi-totality of the debt to be paid in accordance with the terms of the agreement. And I say, in the same breath, because we've touched on the subject, that the reading of clause 2, by use of the word or, and the or is dealing with the request from Mr. Christen to the trustees, if they refuse to pay anything to the respondents, that's perfectly acceptable under the agreement. And then you then move on. What actually happened is, it was because the money was given to Mr. Christen, he paid a sum to the respondents, and that sum, I mean, it might have been a bit cleaner if he'd paid them 110, but the agreement can be fulfilled under its own terms. And that's why I say there's no breach, because the trustees were entitled to pay nothing. And there's nothing in that clause 2 that prevents them paying Mr. Christen. And there's nothing in that agreement that says if Mr. Christen gets paid the money, he's fixed with some kind of constructive trust on behalf of the lawyers, because that would create difficulties for his other creditors, who are also anxious to have some kind of arrangement made with regard to their debts. And in the divorce hearing, the debts owed to family members were found to be genuine debts. They were not debts that were sort of soft Thomas and Thomas debts that would never have to be repaid. They were found by the judge on the insistence of Mrs. Marshall that they were genuine debts. They can't simply be discounted at this stage now as being somehow plastic or elastic. They are debts that need to be paid. And if Mr. Christen does tumble into bankruptcy, the members of his family would prove in that bankruptcy and attempt to get something out of the whole arrangement. The banks have sold off 2 of his investment properties at a net loss, and they are seeking the 3rd one now. And so it's had genuine consequences. But there's nothing that Mr. Christen did amounts to a breach of clause 2, unless a strained construction is placed on it. Because what clause 2 deals with is asking the trustees. And the asking the trustees appears in the amended statement of claim. It's something that the respondents can't possibly know, and appears to be at odds with the correspondence exchanged when Mr. Christen explains to Mrs. Marshall that, I've been dealing with the trustees and they become all very tetchy. And so I just asked them to pay me, and then he paid them. He didn't leave them in the lurch. So that's what I say about clause 2 and its breach. And I say the actual injunction obtained and sought was not proprietary in nature. The agreement was not breached in clause 2. And if you look at the transcript, if I take your Lord and Ladyship to the transcript, what Mrs. Marshall describes, it's in First Hill, that's me. And
What tab are we looking at, please?
I'm going to have to find it. Tabs.
Don't you quote the relevant bit in your skeleton?
No, because I only had 10 pages, so I couldn't put that much quotation in. But if you look at I think it's tab 5. Towards your Lordship will see the transcripts, which appear at page 20 odd and following, 21.
Sorry, I can't hear you because you're not facing the microphone.
From pages 18 and onwards is where Mrs. Marshall describes what's going on. So she describes her application at page 18 and 19. And that's the number at the top of the page, top in the middle, I'm referring to.
Sorry, which tab are you at?
5.
This is your affidavit?
Yes. And in that affidavit, I attached the transcript to what happened before the learned puny judge. And then she describes at page 20, starting from line 2, she describes, she quotes clause 2, and then she describes its effect immediately underneath.
Sorry, where?
Page 20 of the exhibit to Cameron Hill. The 20 is found at the top of the middle, P20.
No exhibit.
The exhibit, that's right.
No, there is no exhibit.
There is no exhibit.
Well, I have an exhibit.
Well, you may do, but it's not in the record.
I'm lost, I'm afraid, too. Which tab should we be in for this exhibit?
Well, I don't know why mine is the only exhibit left out. It's in mine. Or is it? No, it's not.
Sorry, I can't hear you, Mr. Hill.
No, it's not in the exhibit hasn't been included, but the exhibit contains the transcript of the hearing. And if you'll permit me just to read it, and then we'll work out what happened with that. Because mine appears to be the only exhibit that seems to have been left out. But at page 20 of my exhibit, Mrs. Marshall says, she reads out the clause 2. I guarantee that upon completion of the case and rendering of the judgment, I will ask the trustees for the Andrew L. Prison Trust to exercise their discretion to release to the firm from the net equity and so on. That's clause 2. And then Mrs. Marshall described its effect immediately underneath to the learned judges. Was that the trustees for whatever his entitlement to the equity of Mirabeau would pay the outstanding fee. If there wasn't enough, then I would look to the charge over the New York property.
Mr. Hill, contrary to what you said a moment ago, you have in fact included this in your skeleton argument.
Oh, sorry.
Paragraphs 12 and 14.
She characterizes the effect of that clause 2 very differently from what it actually says.
I know, you're absolutely right about that, but we don't need to look at what we can't find in an exhibit we don't have, because you have in fact set it out in your submissions.
Yes, well, that must have been done for a reason. But it's a very important point, and it will have affected the way the learned deputy judge addressed the issues before her if she thought that clause 2 provided a guarantee that the fees would be paid.
No.
And it's my respectful submission, it does just the opposite. It refuses to provide such a guarantee. No. And the obligation upon Mr. Crisson is a relatively limited one. He, with all due respect, cannot be characterized as attempting to avoid a debt because he has paid over a sum of money which will see that debt made good.
I follow.
And then he has then attempted to deal with his other creditors. And throughout his dealings with the courts, the sums of money that he owes to his lawyers have always been described as debts. And there's never been a suggestion that they would have an entitlement to the proceeds of sale over and above his. And this was an entirely novel suggestion when it was made by that letter to which your lordship has referred this morning. The injunction that was actually granted was moreover in form and arrested all of the accounts. And the mechanism by which it was obtained, that is one can see in the transcript, one can see in the writ, one can see in the affidavit. Your lordship has shown paragraphs in the affidavit which could be construed. And I do insist upon that grammatical point of the difference between a fund and funds. And on the basis of all of that, I submit with all due respect that the acknowledgement of debt creates a whole new set of obligations, including obligations to pay in advance, removing rights to complain about the size of the bill, removing a right to make a claim in professional negligence, and sets up its own payment mechanism, which is now still possible and has always been possible.
I understand what you say about removing rights to dispute the costs, but how on earth do you say that the acknowledgement removes any right to sue in professional negligence?
Because he acknowledges that that sum is owed. That's a bit more difficult. But
it's impossible. I agree with my solicitors that I owe them $1 million. That doesn't prevent me claiming damages for their negligence.
I will say this: that it is slightly on less certain ground that it would any claim to professional negligence would be met with the acknowledgement of debt. You've agreed that I owe you this much, and you've thereby extinguished your right to claim. They might be right, they might be wrong, but I would venture that it would be advanced as a defense to such a claim. But it certainly doesn't. It removes his right to have his bills reviewed, which is the usual right, or taxed, or yes, or a mechanism.
The process in Bermuda, is it taxation?
Yes.
Solicitor and client own taxation.
Yes, and there's a mechanism through the Bar Association as well. There are two mechanisms to have them reviewed.
Yeah.
One through the registrar as a taxing master, and one through the Bar Association, the Bar Council.
Right. Just before we hear from Mr. Bachai, can you help me on this? You told us on Monday that it was common ground that your client had asked the trustees to pay the firm, but that seems somewhat doubtful. If we go to tab 3 of the record of appeal, and go in it to page 43, which, as I said, is in fact part of the exhibit to Mrs. Marshall's second affidavit.
Yes.
Your client sent an email on the 13th of December saying, leaving aside the first sentence, I did not seek to withhold or misdirect the funds. I did not think that it was inappropriate for funds to be paid into my account. I was completely unaware that there was a requirement for funds to go directly to MDM, especially as there were more allotted than my debt to you. That appears to be an indication that he didn't understand that he was required to ask the trustees for the funds to go directly to them.
I read that as being a statement that he asked them and that they expressed their reluctance to do it. That was when he learned of all of the serious consequences, and then he said, "Pay me." But
Well,
it seems to me no one has ever, certainly no one's ever said out loud until he amended the first go at this, never mentioned that he hadn't asked them.
Well, the curious thing is he never said he did ask them. Very simple thing to say.
In his affidavit, he says that they became squeamish about paying it. And that includes a necessary implication that he asked them. It could have been more clear, but they became squeamish. And one of the reasons they became squeamish is because Mrs. Marshall was asking for all of it.
Yeah, I see.
And not just the sum due. And that created even bigger difficulties for the trustees. And
Slightly curious that in these vast affidavits, nobody actually put the simple sentence, "I asked them."
I think, and I submit that it's borne out in that affidavit, that email that your lordship has just read bears the reading that they were indeed asked, and the difficulties that they viewed were explained to Andrew, and it was at that point they said no, and he said, "Well, pay me, and I'll deal with it." That's my reading of that email.
Right. Okay. Thank you very much. Right.
Does your lordship need to hear me terribly much on affirmation?
Well, speaking for myself now, it seems to me all this stuff about repudiation and affirmation and rescission is entirely irrelevant. It's not a claim in damages. There hasn't been a claim that there's been a repudiation. There isn't a claim that there's been a rescission. And it's not necessary to consider the principles either of repudiation, affirmation, or rescission.
Okay. Well, I was heading them all slightly at the pass, but I
I
do maintain that they have not accepted the breach.
What? Sorry, which breach?
The breach, they say, of clause 2.
But I mean, I don't want to spend time on this, but
no, let's not bother, because I can see your
lordship's point. You don't actually need to accept a repudiation in order to sue for damages for breach.
No, that's true.
Yeah, let's not spend time on that.
Okay, then, in which case I say there are no damages.
You say what they're suing for is a debt claim, in fact.
Yes.
Yeah.
And it gives the way it'll unfold means that there are no damages, or that the damages are only a few $1,000s.
Right. Thank you.
Is Mr. Crisson a bankrupt at the moment?
No, my lady. He is considering it. And his
Are there
bankers
any
are considering
outstanding insolvency proceedings?
it. No,
Has a petition been presented against him?
no. One has been threatened. 2 have been threatened.
Right. And the company and the business, is that in administration or anything?
Not yet.
Right. Thank you.
But it is struggling.
Very good. Thank you.
Right. If I may. Hello, can you hear me?
Just about.
I cannot bring this thing any closer to me.
I think you're going to have to change your office arrangements.
Well, you know, I should have done it in my office instead of doing it in the boardroom, because the boardroom has the big television and the microphone is right under the television.
Yes.
It's some distance away, but I will try and sit here.
Right.
If that helps anyone out.
That's better.
May I just, on the last point that your lordship raised of Mr. Crisson's email to Mrs. Marshall of the 13th of December 2019, may I also remind your lordship of what Mr. Crisson said in his first affidavit, and I have quoted the relevant passage from his paragraph 39 in my submissions at paragraph 50.
Sorry, what am I supposed, which?
If
which
you're
of
looking
your
at
positions?
39, tab 6. Paragraph 39, tab 6. Sorry, tab 9. Tab 9, I apologize.
yes, and I have quoted it in my submissions to make it easy for you.
Where have you quoted it?
At paragraph 15 of my submissions.
Right. Yes.
Yes, so this is what Mr. Kristen said in his first affidavit at paragraph 39. Once the ruling was eventually issued, the funds in the hands of the trustees could be paid out to myself and my ex-wife. I was told by Mrs. Marshall that the trustees were delaying payment of the proceeds of sale. She insisted that I make immediate and forceful representations to the trustees to make payment. And that, of course, is payment to her firm in accordance with the acknowledgement agreement. I therefore began a campaign of placing pressure on the trustees to pay out the proceeds, not to Mrs. Marshall's firm, because he then says, I felt that I had a right to those proceeds without having to pay further legal fees, about which I was sensitive, about which I was understandably quite sensitive. So he's saying two things there, it seems to me. He's not, first of all, saying, I asked the trustees to make payment of the funds owing to MDM to that firm. What he's saying is that he put pressure on the trustees to pay out the proceeds to himself because he felt that he had no responsibility to pay any further legal fees beyond the $100,000 which he paid out of those proceeds that he received. Now,
can I just be clear?
Yes.
I need to be addressed first. I mean, on the question of whether or not there is a proprietary claim and a possessory lien. I'm, as the president made clear to Mr. Hill, really the question of whether there was a breach or not is a bit of a sideshow in relation to the issue we're actually dealing with, which was, is there a proprietary claim?
Yes, absolutely. And what I would like to do here, my lady, if I may, is just to cover some of the authorities and the principles that the Supreme Court referred to in the Edmondson decision of 2018. Because what they do is to recite the history of the solicitor's lien, the purpose of it, the importance of it, and I think that will help you in determining the question which is before the court. So if you look at tab 1, please.
The point I'm making is whether or what the terms were as to whether he was obliged to ask the trustees, whether he did ask the trustees or not. At the moment, and no doubt you'll tell me, I can't see the relevance of that to the prior issue as to whether or not, after the agreement was entered into, the possessory, the lien of the solicitors remained in existence.
Yes, the lien remained in existence. Absolutely. Now remember, the basis on which Mrs. Marshall continued to represent Mr. Christen never changed. The order was made to allow her to remove herself as the attorney. It never came into effect. She continued to represent Mr. Christen after January of 2018, which was the date of the agreement, in the same way as she had before. All that happened there was that her future fees were capped at $50,000. The amount which was written off did not precede 2018. The amount which was written off was for work which was done after 2018. And she felt that she could not ask Mr. Christen to pay it because the agreement capped the fees at $50,000. So the retainer never changed. All that the agreement does is to represent the means by which the debt was to be paid. Because Mr. Christen didn't have the money, she continued to represent him on the basis that the house had been sold, the proceeds had been paid, and then there was obviously a question of what apportionment should be made to those proceeds as between Mr. Christen and Mrs. Christen. The judge decided that in partial satisfaction of Mr. Christen's debts, he should receive an amount of $400,000 out of the proceeds of sale of the former matrimonial home. That was in the hands of the trustees. Mr. Christen had an obligation. He guaranteed that he would ask the trustees to make payment of funds sufficient to satisfy the debt to Mrs. Marshall's firm under the agreement directly to her firm. He failed or refused to do so. The money was paid into his hands, and he has an obligation under the solicitor's lien claim to make payment of those funds to MDM. And these are the passages that I think you will find relevant, if I might. There aren't that many, but I think you will find them to be particularly helpful as it relates to the way that the Supreme Court described the history of the solicitor's lien, the purpose of it, and the protection it gives, and the benefit and the protection it gives, both to the client as well as the solicitor. So if your ladyship and my lords would look at tab 1 of my authorities, this is the Gavin Edmondson case of 2018. If you wish to have a quick read of the headnote, I will then move on to the relevant passages at page 2064. So my lady, the page is 2064. It's between letters C and D. Where all of the members of the Supreme Court, Lord Briggs, Baroness Hale, Lord Kerr, and Lord Wilson, and Lord Sumption, all agreed, as you will see at page 2055. And they here discuss the history of the solicitor's equitable lien under the heading The Existing Law. The earliest decision to recognize the equitable lien was Welch and Hull. The plaintiff obtained judgment for £20 and costs in a civil claim for assault. But then compromised the claim for a direct payment by the defendant of £10. There was no collusion to defeat the solicitor's right to payment of his bill. Lord Mansfield said this at page 2.
You needn't read it all out to us, I don't think, thank you. If you want us to read to ourselves.
May I just bring your attention then to what I consider to be the relevant passages. So in the passage that's quoted there, this is an important one. An attorney has a lien on the money recovered by his client for his bill of costs. If the money comes to his hands, he may retain it to the amount of his bill. He may stop it in transit if he can lay hold of it. If he applied to the court, they will prevent it being paid over till his demand is satisfied. So these sentences are very, very important for my purposes, because that is the basis on which the application for the injunction was made to prevent Mr. Crisson from using the money in any other way than to satisfy his debt to MDM.
But I quite understand all this, but this, you're not addressing at the moment the logically prior point as to whether the lien has been lost as a result of the settlement agreement. And that's the point. I mean, clearly, if there is a lien, then all these consequences flow. But Mr. Hill's submission is, no, what happened as a result of the acknowledgement agreement reached in January 2018 was that the lien was lost. So these consequences did not flow. So surely the first point we need to address is, as a matter of the construction of that agreement, was this one of the cases where the taking of alternative security or the granting of alternative security displaced the solicitor's lien in relation to the work that had previously been done on the ancillary proceedings?
No, it wasn't.
That's the logic.
I understand what you. No, all that this is an acknowledgement of the debt and a provision to make payment of it.
Well, you say that's all it amounts to, but what is effectively said is that this was a composite deal whereby the amount of the debt was fixed and a scheme of payments was arranged whereby a certain amount would be paid per month until the judgment. There would be then a guarantee to ask the trustees to exercise their discretion to pay the firm. But if they didn't, then reliance would have to be made on the guarantee. And if that wasn't enough, you get to paragraph 4, where there'd be a payment at £1,500 per month. So it was a package which exchanged for the existing rights of the solicitors to whatever they were entitled by way of fees and to whatever lien they might have been entitled in relation to those fees, with a new set of security, which was the promise to act as in paragraph 2, which was fulfilled, and the charge provided in paragraph 3, which is extant, and the obligation in paragraph 4, which hasn't yet arisen. That's the case that's put against you.
And reliance is placed on Taylor and Stallman, which I see wasn't considered in Gavin Edmondson. And I'm just trying to understand what you are submitting that Gavin Edmondson addresses in relation to the decision of waiver of lien or discharge of lien.
It doesn't. It wasn't concerned, I think, with a waiver of lien or a discharge. And the Chief Justice, in his ruling, made the point that the provision of alternative security does not necessarily affect the solicitor's lien.
Well, we know it does sometimes because Taylor and Stallman, which is the one case we've got in the bundle, I think, dealing with this situation, tells us that it does in certain circumstances. So speaking for myself, I would like to receive your arguments as to why you say, with reference to Gavin Edmondson, if appropriate, why you say this is not a Taylor and Stallman type of situation.
And there is, as far as the Edmondson is concerned, there is the principle that the Lord President has already referred to at 31, quoting from a 1795 case, the principle by which this application is to be decided was settled long ago, namely that a party should not run away with the fruits of the cause without satisfying the legal demands of his attorney, by whose industry and in many instances at whose expense those fruits are obtained.
That's the rationale for the existence of the doctrine of lien in the first place, or equitable lien. That doesn't deal with the point that my lady was addressing, which is whether or not what are the circumstances in which, although previously you had a lien, by reason of taking some new security, you lose it.
On the basis that the retainer continues? I mean, this is not a case where the work that was being done by Mrs. Marshall came to an end in 2018. Yes, she applied to come off the record, but that was not perfected. So she continued to represent him based on his promise to make payment of her outstanding fees as endorsed in the acknowledgement agreement in the way of the mechanism provided in that agreement. I can understand if the entire legal relationship came to an end in 2018, this might have replaced the retainer between the parties, but it didn't. The retainer continued throughout until the judgment was handed down in November of 2019. So in my submission to you, the solicitor's lien continued all the way through.
But when did it become established that as a result of Mrs. Marshall's efforts, the property was going to be, the matrimonial property was going to be available to the trustees?
No, when was it established that the $400,000 was going to be available to Mr. Crisson? Because the property had already been sold. The money was being held by the trustees of the Andrew Crisson Trust in escrow pending the outcome of the court judgment. The court gave its judgment in November of 2019, deciding what should happen to Mrs. Crisson's claim, and decided that out of the proceeds of sale, and that was November of 2019, Mr. Crisson should have $400,000, which was recovered on his behalf by Mrs. Marshall. So it was 2019. Sorry, Mimi.
Sorry. So you say the retainer continued, and therefore the lien to any fruits might be expected to continue until such time as there was a decision in Mr. Crisson's favor that he should have a slice of $400,000 out of the proceeds of the matrimonial home.
Yes, absolutely right.
Could I just ask, would you go further than that and say that if the original lien was traded in as part of the agreement, but after the execution of the agreement, the trustees didn't pay MDM, and the £400,000 was released by the trustees to Mr. Crisson, would there be any circumstances in which the lien came back into existence, or a new lien was created from that point?
If it was lost. First of all, I don't agree that it was lost. But if it was lost.
I'm assuming it was lost, but yes. Does that mean lost forever, or can a new one come into existence as a result of the best hopes of how the settlement was going to work out not being fulfilled?
Yes, absolutely. She continued. You see, the thing is here that she continued to represent him. I mean, this was the whole basis on which he agreed to this arrangement. He did not want Mrs. Marshall to stop representing him. He wanted her to continue to act for him, which he did on the basis of the same retainer. And if, for some reason, the lien was lost because of this, which I don't admit, his non-payment established it again, as your lordship says, yes. You could go further than that.
Well, that could well be a strong point, but one can imagine circumstances in which a security is given very early on in a retainership. I'm a relatively rich man, and I go to solicitors with some rather speculative litigation, and I say, I want to instruct you on the basis that your fees will come and will come only out of my mortgage of my apartment block in New York, or my apartment in New York, and nowhere else. And in those circumstances, it could be said that there was an agreement that whenever the fees became due and however long the retainer lasted, you wouldn't have a lien because your sole right of recourse was against the apartment in New York. One has to look at the totality of the circumstances. I mean, as I see it at the moment, what is said on one side is that this was a deal whose curious characteristics were that it had been agreed what was due in respect of the past and what would be due in respect of the future, and what would be due in respect to the future had already been paid. And in those circumstances, you had to look, in order to determine what rights the solicitors had, you had to look solely at the agreement that they made, which is a package. That's one way of looking at it. An alternative way of looking at it is to say, well, the agreement contemplated that the trustees would be asked to pay the firm. Of course, they weren't bound to pay the firm, but the one thing the parties can't have contemplated is that although the trustees paid Mr. Cohen's so that he could pay the firm, he was only bound to pay a portion of the costs and could deal with the rest as he liked. Those seem to me the two of the opposing possible interpretations.
But even if you look at the first interpretation, my lord, if you look at the first interpretation, there was a clear breach by him on the evidence which is before you, because we have already established that there is no evidence that he actually asked the trustees to make the payment under the acknowledgement to MDM. In fact, the evidence is to the contrary. He seemed to be insisting with the trustees that the payment should be made to him. And that would have been a breach of the acknowledgement agreement if that stood alone and replaced the rights.
That gives, I'm afraid, rise to another interesting question. If the position is that the agreement didn't have any effect on the lien. It didn't exclude any rights of lien. The question doesn't arise. But if the position is that there is a potential, that there is an exclusion of express or implied of rights of lien by virtue of the agreement, what then is the effect of a breach of the agreement? It could be said, well, if there was a breach of the agreement, you'd have to ask what the trustees would have done if they had been asked. And we can be pretty clear what it was, because we know what they actually did.
Well, I'm not sure. I mean, the trustees were given notice of the acknowledgement agreement before the judgment was rendered. They acknowledged receipt of that notice. They didn't actually say to Mrs. Marshall, look, we've got your letter, we've seen the agreement, and you should understand now that we have no intention of paying you. So I'm not sure that the answer necessarily follows that they would have paid Mr. Christian if he had asked them to pay it to MDM.
But anyway, this is not a claim for damages for breach of the clause.
No, so in the one case, in your first scenario, it's arguable that there was a breach on his part of the agreement in failing to ask the trustees, and in the other case, that the solicitor's lien was not defeated and it continued to have full effect. Anyway, the importance and the importance of the protection, my lords, of the solicitor's lien is set out in the Edmondson case. So I was going to mention the reason for it, if that assists you. If it doesn't, then I won't bother.
Well, I think we know the reasons for the lien. It's in order to ensure that solicitors are prepared to act, especially for the needy.
Yes, exactly. And that appears.
Priority interest on the. It's before the days of conditional fee agreements, but yeah.
Yes, my lord, and that appears in paragraph 33 of the judgment. At 34, I think it is of great importance to preserve the lien for solicitors. That is the real security for solicitors engaged in business, and it is also beneficial to the clients. And then we go on to the passages that I have cited to you as forming the basis of the proprietary claim. In this case, I have already mentioned to you that in my view, the retainer was never terminated, and that is clear from the provisions relating to Marshall, Deal, and Myers coming off the record. I have brought your attention to the affidavit which Mr. Christen swore. I have mentioned that the fees that were written off were not fees that were incurred prior to 2018, but fees which were incurred after 2018.
Could we just have a look at the only authority on extinction, which is tab 11 of the bundle, Taylor, Stallman, and Underwood. I see from page 591 that the summary in the head note is put as follows: that whether the taking security by a person having a lien is an abandonment of the lien depends on the intention, whether expressed or to be gathered from the circumstances of the case, that prima facie, where a solicitor whose duty it is to advise his client as to his rights and liabilities takes from his client a security for costs without explaining that he intends to reserve his lien, the lien is abandoned. How does that apply in this case?
I'm not familiar with the facts of that case.
Well, what appears to have
But
happened is that the solicitors took a promissory note. Quite a strong court.
I don't see any reference to the funds being collected under the promissory note. That seems to have been discovered after.
Well, yes, that was what happened. The existence of the promissory note was discovered after the first instance decision.
Yes, I see that, Madam. I think as your lordship has said, yes, sorry?
No, no worry.
I think as your lordship has said, you have to take account of the position of the parties and all the circumstances. I mean, it's right that I've not seen anything to suggest that MDM had any discussion about the abandonment or the continuation of their leave.
Well, it's not clear to me, if I may respectfully say so, whether MDM had any concept of lien in their minds at the time, because it only got referred to in this case in February 2020.
Yes, my lord, I would have to agree with you on that. But then, as I say, on the two scenarios that your lordship gave, the first one, of course, would involve a breach, which is what was originally pleaded, and which was the basis on which the injunction was granted in the first place. A breach by Mr. Crisson of the acknowledgement agreement.
Well, the basis on which the injunction was granted is slightly obscure, because the claim for an injunction was a claim as against the 400,000 in the bank account. The injunction actually granted was against any bank account and was in Moreva form. And the judge was informed that the solicitors had a guarantee that they get money from the trustees, whereas that wasn't true. So the whole thing was something of a muddle.
But the writ itself makes the claim for breach of the agreement. Because Mr. Hill says over and over again that there was no pleading which alleged a breach of the agreement. And of course, your lordships will see at tab 1 of the record and paragraph 9, the pleading was that on or about the 12th of December 2019, and without the knowledge or consent of the plaintiff, the defendant had the funds transferred from the trust to his personal HSBC account in breach of the acknowledgement of debt and payment agreement. So if you decide that, contrary to my argument, that in fact the retainer agreement continued and the lien was preserved, or, as Lord Justice Kay said, that it was re-established after 2018 when Mrs. Marshall continued to act for Mr. Chrisson, the pleading made it clear, at least in the first instance, and that has been preserved in the amended writ.
And what did the pleading make clear? What did the pleading make clear?
That there was a breach on the part of Mr. Chrisson of the terms of the 2018 agreement.
Well, in fact, it's remarkably opaque, because paragraph 6 says that the defendant agreed that he would ask the trustee to exercise their discretion to release the net equity to MDM. It then says that the plaintiff made demand for payment. It then says that without the knowledge or consent of the plaintiff, the defendant had the funds transferred from the trust to his personal savings account. Doesn't actually say he failed to ask for it to be transferred to him, but I suppose one can interpret 9 as meaning he asked for the funds to be transferred to him, and that's what happened. And then to date, the defendant has refused or neglected to make payment pursuant to the acknowledgement of debt. There wasn't actually any obligation of the defendant to make payment pursuant to the acknowledgement of debt. There might have been an obligation to make payment in order to satisfy the equitable lien, but that doesn't arise pursuant to the acknowledgement of debt, but arises from the relationship between client and solicitors. So not a model of clarity.
No, I do accept that. It's not a model of clarity, but what it does do is to allege a breach on the part of the defendant of that agreement dated the 22nd of January 2018.
What, in failing to ask for payment to the firm?
Yes, because that was he guaranteed under that agreement that once the judgment was rendered, he would ask the trustees to make payment directly to MDM. And instead, he asked, from the evidence, the trustees to make payment directly to him. And therefore, in my view, he becomes responsible for payment of those fees that he acknowledged existed as at 2018 to MDM.
Well, that may be so, but the fact that he's in breach of contract does not give rise to a proprietary claim in the absence of a lien. Unless you're arguing an assignment. And
But that was the separate scenario that my Lord the President posed, that you, on the one hand, have the agreement existing by itself, and on the other hand, you have the solicitor's lien.
Right.
Mr. Patchai, could I ask you about Stoneham J's judgment, please?
Yes.
Looking at paragraph 144 of Stoneham J's judgment, which I have in the middle of tab 6 of the record.
Tab 6?
It's page, well, there are a number of page numbers on it, so I can't, it's impossible to give you a page.
Do you have a paragraph?
Yes, paragraph 144. Now, I'm right as I understand it, that as at this time, Mrs. Marshall is continuing to act, during the hearings that occur in May 18 and in May 18, Mrs. Marshall is continuing to act for Mr. Crissell. Is that correct?
Yes.
And as I understand it, paragraph 144 of her judgment is dealing with the attempt to vary what is referred to here as the A fund as being a nuptial settlement. And it's the property which is referred to in the letter, the agreement letter in 2018, Mirabeau or Mirabeau, yes, it's called, is this property in this trust. Is that right?
That's absolutely right. The A fund, my lady, would be the Andrew Crisson Trust.
Say again, say again.
The A fund,
yes,
which is referred to in paragraphs 144 and 145,
yes,
would be the Andrew Crisson Trust referred to in the acknowledgement agreement. And it's that trust that holds the proceeds of the sale of Mirabeau. So there was an attempt.
Yeah.
Yes.
So the wife was trying to vary under section 28C, the trust relating to that asset.
Yes.
And the trust, can I just be clear, that trust, what were the terms of that trust in relation to the A fund?
That I'm afraid I don't have the answer to, because I wasn't involved obviously then.
Well, I think it's paragraph 27 of the judgment.
27.
Oh no, that's something else.
No, that's another one.
That's another one. No.
22 refers to the A fund.
That's the X trust, the Y trusts.
No, I think that's what, I think the X trust irrevocably appointed out to the A fund. So the A fund got money from the X fund. And the A fund is a trust established for the benefit of husband, wife, and 2 children. I think that's what it means.
There we go. Yes.
What paragraph are you looking at?
22.
I'm just trying to get a grip on the fact that the proceeds of the, I'm just trying to work out which property it is, that's all, that's in the A fund.
The former matrimonial home, Mirabel,
That is Mirabel.
which was put up for sale,
Yes,
and then the proceeds were held by the trust
right.
pending the outcome of the judgment.
And that trust was for the benefit of the husband, the wife, and the children.
And that would appear to be the case from paragraph 22.
So what Mrs. Marshall's efforts managed to do was to ensure that, as per paragraph 152, he obtained or retained £400,000 from the sale proceeds.
Yes. And that appears, my lady, if you look at my submission to paragraph 32, I have quoted from the order of the 7th of November 2019, which unfortunately we don't have, but which I will send to Mr. Coelho.
Yeah, I think that's pretty critical from my perspective.
Yes.
So you were saying that 17, and that did what? That.
Sorry,
Sorry, could you say that again?
I said that if you look at paragraph 32 of my submissions, you will see
yes,
quoted the passage from Justice Stonham's order dated the 7th of November 2019, which was drafted by virtue of her judgment, where she determined that Mr. Crisson should receive the lump sum of $400,000 from the proceeds of sale of the former matrimonial home held by the trustees of the A fund.
Yeah, thank you.
So I think that gives you the
Yeah, thank you very much.
answer.
Yes, thank you.
Okay. So I have nothing further that I can assist you with unless you have anything particular.
Well, I'm afraid I have a few questions. I raised one of them last time. Well, firstly, slightly obvious question. If you are right, what do you say that we should now do?
Ah, yes, that's right. That raises the question, of course, or the issue that I posed to you earlier on in the week, which is that all we are dealing with here is the Chief Justice's ruling of the 7th of May, in which he found that the injunction which was granted in December of last year was not a Moreva injunction, but in fact a preservation order, against which there would be no exceptions made for living expenses and legal fees in accordance with the Polypec decision. So that was the only thing that he decided at that time. The appeal which Mr. Hill has mounted is an appeal against that judgment. There is another hearing before the Chief Justice on the 19th of January of next year, less than 2 months away now, to determine whether the injunction should be set aside and also to determine the application for summary judgment. So the only thing that I think your lordships can do is to decide whether or not to overturn the Chief Justice's decision as it relates to the living expenses and legal fees, because that was the only thing that he was deciding on the papers.
Wait a minute. What I asked you was what we should do if you were right. What you appear to be suggesting is what we should do if you were wrong.
Okay. If I am right, then I would ask you to find that this, in fact, was a proprietary claim, that MDM do have the solicitor's lien against the funds, that the injunction was therefore well-founded, I'm not sure how much further your lordships can take it. I mean, if your lordship is saying that you can now decide whether MDM should have their money.
The question is the status of what we might or might not decide. This case has been brought before us upon the footing that the answer is obvious, though the answer alleged by both sides is the opposite of the other. But Mr. Hill says it's perfectly obvious that this isn't a proprietary claim. You say it's perfectly obvious that it is a proprietary claim. The learned Chief Justice determined that it was arguable that it was a proprietary claim. There are two questions: A, whether we can, and B, whether we should determine, not interlocutorily, but finally, what is the position in relation to whether it is or is not a proprietary claim. It could be said that we have it's really a question of construction in all the circumstances of the agreement, and we have all that we need. Do you have any submissions in relation to that?
No, I suppose you could do that. I don't see any reason. You have all the material. You have, obviously some of it is missing, but I think you have everything before you.
What would be the status of that decision? Here we are on an interlocutory appeal from the Chief Justice. If we decide that, would he be entitled to say, well, I'm terribly sorry, I have the greatest respect for the Court of Appeal, but it was only an interlocutory decision, and they failed to take account of the following points, and I think they got it wrong.
Well, that leaves open the question whether we would be entitled to re-argue it all over again before him on the 19th of January.
Yes.
I mean, that was a problem that I had earlier on this week, and your lordship was clear to me that if you felt justified in doing so, you could either express an opinion or make a finding.
Mr. Pakai, I think there's an additional point, isn't there, which is that the grant of an injunction is discretionary. And is it appropriate that this court, in deciding whether the judge should have granted an injunction in the terms which he did, is it right that we should have regard to the considerations of other creditors in circumstances where, although there is currently no insolvency proceeding by or against Mr. Crisson, clearly from the evidence there are serious issues as to whether he is on the brink of insolvency?
Yes, my lady.
And
yes.
Just a second, please. Do we, in considering the exercise of a discretion that does not permit the use of that money for his other creditors, have to give any consideration to that point? Or do you say, well, if we decide it's proprietary, it's got to be preserved for the benefit of the solicitor? But say we decide, as the President has just put to you, that it's arguable that it's not proprietary, that there's no lien. In that situation, should we be giving consideration to the need for the appellant to pay his other creditors in deciding whether to uphold the injunction or not? So say we were to come, for example, to the same view as the Chief Justice, that, okay, it was arguable one way or the other as to whether there was a lien and a proprietary claim here. But I'm putting to you, should we take into account the fact that if it's arguable that there isn't, given the other creditors out there, we should be slow to give the proceeds of this to ensure that MDM get priority in the queue?
But not until there is a final determination. And that's your problem. If you come to the conclusion it's arguable, as the Chief Justice said, the matter has to be determined by either you or by him. And we are already before him in less than 2 months' time to argue the very same point of whether the injunction should stand or fall, and whether MDM should have a summary judgment of their claim. So I think at this stage, it would be inappropriate for you to have regard to other creditors, bearing in mind the status of where we are in this action.
Yes. Well, it depends what one means by have regard to other creditors. I can see that if we were to make a decision that there was no proprietary remedy, no proprietary interest, and payment could be made to whichever set of creditors Mr. Christen had in mind, that could be said to be.
If I could just jump in very briefly, if one looks at paragraph 152 of Stone PJ's ruling, she says, "I have no doubt that the husband's need to meet a portion of his hard debt, estimated to be some $902,000, can be met by the $400,000 out of the sale proceeds." So certainly the judge in the matrimonial proceedings was contemplating that this $400,000 would be used, at least in part, to meet some of the $900,000 rather than all of it being used, or the vast majority of it being used to meet the claim of the. So that I didn't want to go on too long, but that was part of that would be part of my 10 minutes.
I mean, there are problems. There would certainly be problems in saying there was no proprietary remedy and making an order which said that anything could be done with the money. One of which might be that the creditors, I suppose that could be done, but that could be slightly unfortunate if is that being done on an interlocutory basis or on a final basis? Don't know. Can you help us on this, Mr. Pachai?
Yes.
The injunction, despite the fact that it was ordered to be, the request was for an injunction relating to the 400,000 in the bank account, isn't limited as to any amount of money, and isn't limited to the Hong Kong and Shanghai bank account. I mentioned this on Monday, and the Chief Justice mentioned it in his judgment and said it would have to be changed. But the position we're in.
Sorry, my lord, I stand to be corrected, but I think the injunction was limited as to the amount.
It is.
Yes.
I'm sure it is.
But it's limited to 400,000.
No.
Oh, no, it's limited to.
It's limited to the amount of their claim, 242,000, I think it was.
Yes, you're quite right.
Yes.
You're quite right. But that was
the order did tab 4.
No, yes, I see. It was limited to that.
Yes.
And
But that's not the sum due. But that's not the sum due under the note. Other bits were added. It was one of my complaints. I'll come to that in my 10 minutes.
Well, but that took account of the 100,000, did it? Yes, it did. Mr. Pachai.
Did it take account of the 100,000 that was paid? Yes.
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 And the 50,000 that had been paid long back.
Yes,
yeah,
of course.
Okay.
Yes.
All right. Okay. Right. Okay. Thank you very much. Yes, Mr. Hill.
I just wanted to deal with a couple of points. The first one is the continuation of the retainer. We haven't seen the retainer. It hasn't been produced.
But when you say the retainer, how do we know there ever existed a retainer?
Well,
What do you mean by physical?
There would normally be an engagement letter of some sort, and I'm assuming there was one. If it's being paid $50,000 in advance, whatever you do. So if it's settled the next day, she got to keep her 50,000, and if it cost 100,000 to finish it, she got to keep her 50,000. That wouldn't be in any normal retainer. That changed the terms. The acknowledgement of debt changed the terms of the retainer because it fixes the sum due rather than a calculation of the sum due by virtue of a review of the invoices sent. And so it is not a correct analysis of how that acknowledgement works to say it is merely a continuation of the existing retainer. Whatever the existing retainer was, but no letter has been produced, no client care letter, no engagement letter, or whatever name you give to it.
Well, if there was one, it would have been addressed to your client.
It would, but my client says it's no longer in existence. We say we rely on the acknowledgement of debt. If anyone wants to rely on the retainer, then it's for them to produce.
Sorry, does he say it no longer exists because I've destroyed it or I can't find it? Or there never wasn't?
I have no instructions on what
but you don't know. He hasn't said anything.
No. But whatever it was, I think we can, as lawyers, all recognize that getting $50,000 in advance, whatever work you do, is unusual and is unlikely to appear in such a document.
One of the questions is as to whether there was a termination of the retainer or simply an amendment of its terms.
Well, I say that it's obvious from the agreement reached and the way it works for payment and the payment in advance of future fees amounts to a termination of the retainer. And in fact, the settlement discharges the obligations of the retainer and creates, by having its own consideration, a new agreement which deals with the entirety of the obligation between the parties. I've been through that already. Your Lordship have my submissions. The additional point is that the question of the other creditors. I've been dealing with them to some extent, and they had never imagined that there was any proprietary claim because having read this judgment, it says what the debts are, who the creditors are, and how the money can be used to pay those creditors. And they do have an interest to protect. Now, they've been unwilling to engage their own counsel and prepared to rely on their interests coincide to some extent with those of Mr. Christen's, and he'd end up with the bill. So you might as well just have one rather than three of us sitting here because there's two banks. Both of them are pursuing him. And he's in extremely difficult straits. He is interested in presenting his own petition for his insolvency, and I have convinced him to wait and see how this unfolds.
I mean, isn't the problem that the judge specifically envisaged that this money would be applied in discharge of his creditors' debts?
Yes, that's one of the issues that I think is important for us all to bear in mind.
No, it was never envisaged that this money would, so far as the judge was concerned, that this money would go to pay past fees of the...
Right. Yes, that's exactly, and the judge says so in terms.
Or advocates' fees, attorneys' fees.
Pardon?
save to the extent, I suppose it could be said, that they were amongst the creditors of Mr. Crisson. Well, they
That's
are.
what- That's what's said in the, but if they have a proprietary interest, then the use of the word creditor is not quite,
no,
because they don't have to prove they have money that comes out as a secured claim, and so that money would not be available, whatever happened, to meet the creditor's claims. I certainly don't think she envisaged more than half of it disappearing in past fees. And that does arise in the way that the discretion is exercised.
I mean, theoretically, under the matrimonial legislation, she could have varied the trusts so as to provide that the 400,000 was held on trust to pay the husband's creditors pari passu. Now that might have been a strange order. It's not.
That's right, and she applications were made.
Just a second, let me finish. It's not the sort of order that a family judge might appreciate she had the ability to do, but it is certainly a possible order if one's varying trusts.
Yes, I see that. An application was made for the cost to be paid out of the fund, and that application was rejected.
Sorry, application was paid by MDM?
I believe so, yes.
Where do we see a record?
It's in, I don't think I'll go down that road because I don't have enough to support it, but there was an issue with the costs, and she mentions it in her submissions that she makes.
Well, I think, Mr. Patchai, you may not want to go down that road, but I think I would like to hear from you or Mr. Patchai as to whether that submission was indeed made and was rejected.
I just don't.
Was it a submission made by MDM or was it a submission made by the wife's solicitors?
MDM.
Well, I think I would like to see the record of that.
Was the order of it made in the end no order as to costs?
Correct.
No order as to costs.
And that order as to costs was made upon the application of MDM that their costs be paid out of the fund, and I believe out of the funds that would go to Mrs. Christian. I don't have a big window on that. There is reference to it in the correspondence, and I think in the.
Well, it depends what you mean by the fund. Are you referring to the £400,000 fund, or are you referring to the funds that went to the wife? Because if there was an express ruling by the judge, by Stoneham J, that the solicitor's costs should not be paid out of the fund, that, speaking for myself, might be relevant to the exercise of any discretion that this court thinks appropriate.
No, I don't believe there was any such ruling, Michael.
An application was made for cost, and they were not to be paid out of the trust. And I think that's that the parties will want that. She in fact refers to it in her ruling, which is Christian exhibit.
Well, I think you need to send Mr. Coelho by email, please, the reference to that if you're relying on it.
Paragraph 167 of the Justice's matrimonial ruling, page 126 of the exhibit. She makes an order that the parties should be responsible for their respective legal costs. And my understanding and recollection is that she refused an application by MDM that the costs be paid otherwise. And I'm unable to say with precision exactly the nature of that application. I haven't seen what was asked, but it was in response to an application by MDM as to costs coming out of the fund, I believe, that order was made. That the parties should be, because there were issues with how Mrs. Christian had conducted the litigation.
Well, we cannot rely on what you've said to date, I'm afraid, Mr. Hill.
No, I
And
accept that, but
specific.
I don't want, and that's why I said I didn't want to take it. I didn't have enough to go on. I haven't seen the actual application. I've seen it adverted to, but not in any sufficiently detailed sense that would allow me to say one way or the other.
Well, I think, speaking for myself, whether you want to rely on it or not, I would like to see the application, because if the position was that the application was for MDM's costs to be paid out of the husband's share of the fund, and the judge declined to do that, in other words, she wasn't prepared for that to happen, it might be that any equity that existed for a lien on the fund ought not properly to be exercised in circumstances in which the solicitors had not informed the judge, oh, well, we're going to claim the whole of it anyway.
My lord, perhaps the answer is that I should make inquiries to find out precisely what application was made.
Yeah.
And if anything was submitted in writing, I can provide it to you.
Yes, please.
Yes, so I will undertake to do that.
Thank you. Thank you very much.
But that question is dealt with quite the question of how the fees are to be treated is dealt with in the ruling, in that they're included in the general body of creditors. And it's my submission that being part of the general body of creditors is an express finding that they are not secured creditors and secured by a lien against the fund. And if you look at her ruling, which is in First Christen in the exhibit, she sets out in quite a bit of detail the financial position of the parties.
Whereabouts?
It's at page 114, paragraph 111. 111, pardon me, and following. Should I read it? She says the husband's evidence is that he remains employed by the business.
Sorry, where's it? I can't hear you because
Paragraph 114. You needn't read it to us. We can read it for ourselves.
Very well.
Yeah.
And that also appears in Mrs. Marshall's submissions, which I think immediately precede the judgment, where she set out the accounting and she says that the legal fees are a debt and they're being paid by this $1,500. I'll see if I can find the submission. Yes, they start at page 34.
Of what?
Of the same exhibit. The number I'm using is the one at the bottom center. Page 34 is where the respondent, that's Mr. Christen's respondent submissions drafted by Mrs. Marshall. And as you go through that, she sets out what she says.
I'm sorry, I'm not clear what page. Are we in tab 6 still?
Tab 6, the exhibit to the first affidavit of Mr. Christen.
Well, there are lots of exhibits.
At page 35, and that 35 is at the bottom in the center. 34, pardon me. That is where Mr. Christen has included the respondent's submissions. That is, the submissions made on his behalf at the matrimonial trial. This is Mrs. Marshall's position at that point. And again, if you head towards the back, I'll get there eventually. He says at paragraph, I'm getting bogged down.
What paragraph?
She deals with the under the heading the A trust. She deals in these submissions with the effect of these rulings upon the other beneficiaries of the various trusts.
Sorry, where are you reading from?
Hang on a moment, I'm getting myself together. Okay, if your lordships and your ladyship have page 114 of the exhibit to the first affidavit, and the 114 number I'm referring to is in the bottom center.
Are we still in tab 6?
Yes. Not sure if this is still
I don't have any numbers in the bottom, not sequential numbers.
Let me.
Is this the judgment?
No, it's the submissions of Georgia.
Well, can you give us the paragraph number of Mrs. Marshall's submission?
I'm trying to get there.
Is it around 110, 111?
Yes. That's what I've got the first time.
I'm only getting that from your 114, page 114, which is illegible, really. But the next page is 115. I think the 114 is caught underneath the spine.
Yeah, I hadn't expected to go to this.
That's the judgment of Justice Stolen.
No, it's the submissions of Georgia.
Was the pagination given by a child?
This whole tab is all over the place. You get a non-sequential part of the judgment and omitted parts of the judgment and parts of the submissions, and very difficult to follow.
Well, I shall leave it simply then with the ruling. The ruling says that they're all debts that appear to be pari passu. None are described as being secured or forming part. And then she expressly says that he can use the 400 to meet his debts without apportioning them. And that the submissions immediately precede the ruling. There does seem to be some confusion about them. And I have relied on that, on the discretionary point, is that this injunction does not take account of any of the third parties. And that is not obvious from the way the Stonham's ruling went. It appeared that everyone was going to be treated the same. And if you read that ruling, you would be surprised to learn that suddenly Marshall, Deal and Myers were popping up and saying, actually, all that money's ours.
Right.
Yes.
The ruling that I was going to be seeking was a discharge of Mr. Hagen's order, a finding that the application, that there's no proprietary right to the money, and that because of the payment of the 100,000, as I've already been through, the actual damages, if you follow the agreement, are de minimis and would amount to the difference in the 250 that would be paid by Mr. Christen paying 100 and then 150 coming from the agreed guarantee. If there's anything left, that would be, and in fact, I say there's no damage because everything is dealt with under the agreement. And so there should have been no injunction at all. And it should be, and the Chief Justice, when he was confronted with the application indicating that it was a proprietary injunction, should have gone into all of these matters, that it was improper of him at a time when no one has heard an inter partes application on the matter to absolve himself of the analysis that we have gone through today about the existence of the lien, the nature of the obligations created by the acknowledgement of debt, the question of whether or not those obligations remain intact, and what happens if they're all followed through, is that Marshall Deal & Myers will be paid in full in accordance with its
Can you
terms.
just help me on the figures? In the 2018 agreement, the outstanding fees were 280,000 roughly. And then 150,000 would come from the guarantee in relation to the New York apartment.
Correct.
That's 130,000 left owing.
Yeah,
Why isn't that on any of you to be paid?
Okay, because 100,000 of it was paid by Mr. Christen.
But oh, yes.
And then he's been paying the 1,500 every month.
Yes, I see.
I think he missed a couple of months. I think the number is slightly more than 150 still owed. And that number is covered by the clause 4 sweep up. But it's in the grand scheme of things, it's not a very big number. And these facts too should have gone into his discretion and the discretion of Stoner, but we're not here to deal with Stoner particularly. All of these things should have gone into the exercise of discretion as to whether or not a proprietary injunction should have been issued, which in fact covered debts other than debts due under the acknowledgement.
So he's been paying £1,500 per month, what, since 2018?
Yes, I believe he missed a couple of payments.
Well, the obligation under the 2018 agreement was to make $1,500 per month until the judgment of the court is rendered.
Yes, and my understanding is he complied with that, and the debt was reduced by $1,500 a month, and that's what gets rid of the 30,000 odd, because there was quite a long time between the agreement and when the judgment actually came out, which was nearly 2 years actually.
No, yes. Right. Okay.
And I believe there is a balance over and above the 250, but it's de minimis in the grand scheme of things. It certainly didn't merit an application of this nature. And I submit that the learned Chief Justice ought to have undertaken the analysis that we've undertaken this afternoon. And he may have found that it was a proprietary injunction anyway, but he didn't undertake the analysis. He simply said these words could be construed as giving rise to a proprietary injunction. And he didn't take on board the notions that we've developed today. And if he had, what comes out is there is no damage.
I don't think the Chief Justice was invited to do that, was he?
He was invited by me to say that there is no damage, yes. It's in my submissions.
Is it? Oh, okay. Right. Thank you. Well, it may not surprise you to learn that we will take time to consider what our judgment shall be. Thank you both very much.
I'm grateful for the... Did you have a question, my lady? Pardon me?
No, I was just saying thank you very much for your submissions, both of you.
I wanted to say thank you very much for you allowing the hearing to go ahead so late in the session, and to Mr. Coelho in particular, who managed to assemble those documents and just get them to the panel, your lordships and your ladyship, lickety split, and it couldn't have been done without some goodwill on everyone's part, and I am grateful, and so is my client.
Thank you.
Thank you.
Thank you.
These proceedings are now adjourned. Mr. Pashai and Mr. Hill, if you could leave.